Yeah, yeah. Party people, let me see you now. Throw your hands up, yeah. We got the good rhymes, we're making the good times. We're taking over your mind and we're getting the good vibes. Now you're telling me don't stop the melody, good times ahead of me. Yeah, we got the good rhymes, we're making the good times. We're taking over your mind and we're getting the good vibes. Now you're telling me don't stop the melody, good times ahead of me. Yeah, we got the, yeah, yeah. Party people, let me see you now. Throw your hands up. We got the good rhymes, we're making the good times. We're taking over your mind and we're getting the good vibes. Now you're telling me don't stop the melody, good times ahead of me. Yeah, we got the good rhymes, we're making the good times. We're taking over your mind and we're getting the good vibes. Now you're telling me don't stop the melody, good times ahead of me. Yeah, we got the good rhymes, we're making the good times. We're taking over your mind and we're getting the good vibes. Now you're telling me don't stop the melody, good times ahead of me. Yeah, we got the good rhymes.
Hello, everyone, and welcome to today's stream. It is 6/5/2026. Hello, everyone in the chat. Lyle already starting off with the jewels. Thank you. I was on replay crew for one of the lives, headphones in at work. Bacon said, "May Dave be with you," and I blurted out loud "and with you," and then had to act like I was on a call or something. Oh, Jupiter's with Bruce. Yay. Have fun. Welcome. Happy to have you all here. Replay crew, happy to have you here. One thing, housekeeping, that I want to address at the top of the stream immediately. As I was getting up, thank you. As I was getting set up today, I often like to come down and get all of my screens set up and all of my stuff, and then I listen to whatever. So I saw that Llama was on stream, and I went into her stream, and immediately she has had an unexpected loss in her family. So if you don't know who Llama is, True Crime and Wine, they are another group of creators. I would say there's about 3 of them. I know Buffy, I know Llama, and then I believe it's Terry with True Crime, who's also on that channel. They stream and they talk about Laura Owens, but they talk about other cases and other court cases as well. I've had the pleasure of being able to stream with them. And so I went in. She has experienced loss inside of her family. They have a GoFundMe link that she's been talking about. So I took that link. I posted it in the description of this video. I have already personally donated. If you guys have the ability to do so, I have it. So you just go into the description box of my video and look for it. I posted it on my Twitter. I posted her video on my Twitter. I have seen this community be amazing. And everybody in this community has been so wonderful to myself. And when, you kind of get this sense of community, but also just these peers that you have, and you see them in some sort of pain, you're just like, what can I do? How can I help? So I did that. If you guys are interested, it's below. It's on my Twitter. So there's that. Yeah. Hello, everyone. Okay. So today we're going to be going over this hearing. I know that we have already listened to this, but we're going to listen to it again. I have figured out how to gain up the stream. It's about 40 minutes long. The reason that we're watching it again is because I want to just go through everything linear in the timelines of these men. So we have covered everything at the surface, and now we're just diving way to the depths of the 7th layer of hell. So today we have the Greg Gillespie hearing. This is Laura Owens versus Greg Gillespie on November 9th of 2023. We will get started in just a second. If you are not subscribed, please consider doing so. It really helps out the channel. Hype, smash your face against the keyboard, break something in your office. I don't care. It's fun. It's cathartic. With that being said, we are just going to get started in today. So here is the judge. And here we
CV
go.
220. I'm just going to go back there and start over again. This is CV 2021-052893. I'm going to ask the parties to please announce.
Thank you, Your Honor. Kyle O'Dwyer, representing plaintiff Laura Owens.
So we have Kyle O'Dwyer for Laura Owens, and we know that Kyle is her seventh attorney, according to the Volo website. He would withdraw soon. This is Greg Gillespie. This is his wife. I don't know who this woman is. I assume it's somebody here for Greg and his attorney.
Good morning, Your Honor. Fabian Zizweta representing Mr. Gregory Gillespie.
Hi, say cheese. Hi, howdy. Or hi, howdy.
Good morning
Hi,
to the
Shawnee.
two of you folks. We're set for cross motions for partial summary judgment, each on each other's claim, and remarkably raising almost identical issues, both directions.
Yeah, remarkably raising issues. Gotta boost this hearing as well. Again, do you need me to? Oh, sound is good, hair is good. Thank you. Oh, Greg's aunt. Okay. It's funny that he says this right off the top. Remarkably, you both have the same arguments against each other, and it's like remarkably, maybe you could listen to the case. This is a hearing. Maybe look at the evidence. But don't worry, we're all gonna leave pissed off.
Read the motions, the responses, the replies, the statement of facts. Is there a preferred way to go?
Also, you will notice that Laura Owens is not present in the courtroom again, which she should have to. You should have to. Yes, we do have closed captioning. Let me get that for you. I'm so sorry.
Who goes first? We'll start with the plaintiff. Plaintiff can go first.
Thank you for
Why don't you address
asking.
both your motion and the response to the cross motion, and we'll go back and forth that way. Can you, I'm hard of hearing, so that's why I'm wearing this, but you can either lean into the microphone, or if you want, you can use a podium. Just so long as I can hear you, that's all I require.
So it's okay if I remain seated, Your Honor?
Yeah, I've heard you fine. Perfect.
Thank you, Your Honor.
Yeah, I remember watching this one because I said he looks like the villain from Die Hard. The first one, Alan Rickman. Hans. He's Hans.
I'll start with my client's motion, plaintiff's motion for summary judgment regarding all of the
I believe so. I believe she was supposed to be pregnant by Clayton at this time because when you go back, she is already fighting. And there was a hearing that I skipped that was with Clayton because we'll go through that when we cover Clayton in depth. But yes, I believe she's supposed to be pregnant at this time by Clayton that he does not know about. I don't believe.
defendant's counterclaims. Your Honor, as indicated in the motion,
Hi, Don.
my client is requesting that the court dismiss both counterclaims on two premises. Well, both of them because of a lack of damages and the intentional infliction of emotional distress, or IIED claim, for also lack of severe emotional distress. Your Honor, it's clear based on the information provided to the court that there can be no damages.
They're the same person. That's him right there. That's him right there.
Is at trial at an arbitration hearing in this case. As the court noted in the disclosure statement, there was absolutely no damages calculation whatsoever provided by the defendant for his claims.
That's okay, IB.
Nothing at all regarding what dollar amount he would be seeking.
Bacon Boots, this is November 9th of 2023. R.I.P. Alan Rickman. I know.
In response to the motion for summary judgment, he attempted to file an affidavit supplementing this disclosure statement, which my client objects to as being way too late. It should be noted the motions for summary judgment were filed the very last day they could have been filed prior to the arbitration hearing, which was set for August 16th. And so this wasn't a summary judgment motions filed early in the process. This was after all discovery had been completed that any party wanted to complete. And we were ready for the arbitration hearing.
Yes, this is on Schnitzel's channel. I don't. Oh, you can't see it, but it has her little thing on the side. Anything that we watch is always from Schnitzel's channel. I take it straight from the Volo website, and it's always goes back to Schnitzel's YouTube channel.
And so my client objects to that statement, but even if the court considers the additional information in the declaration,
Hi, Amy.
that is insufficient to create a genuine issue of material fact regarding damages. And the reason for that is all it says is $50,000 for lost income. No basis whatsoever on how we get there. So if this case goes to an arbitration hearing before the arbitrator, Mr. Gillespie can testify that I incurred damages of $50,000, that I am a salesman since 2019, but he can't testify about any commissions he got in the past. He can't testify about any days that he missed and how we get there. Because, Your Honor, if he didn't miss any time, there's no basis for the claim. Because he's saying I missed opportunities for income, for commission, based on the emotional distress I suffered. But he hasn't provided anything about how much time he may or may not have missed. Doesn't provide anything about what commission rate he gets. Is it 1%? Is it 75% on his sales? Hasn't provided anything on his historical record of commissions. Has he ever gotten commissions? Nothing is there. And so, Your Honor, summary judgment.
You know, if he really didn't put that into discovery, I mean, that's a choice that him and his lawyer made. And if he, that's not something that he wants to testify to, I mean, I would tell him how he got there. But I think one of the main points that Greg would have is because you have physical proof, is to show the physical proof that Laura even said herself that she contacted his work, his place of employment, trying to get him served, trying to mess with that income. I think that would be extensive proof on the lengths that she's willing to go to make it so that this man can't make any money.
Motions have been referred to as a time to put up or shut up. You have to provide your evidence, what entitles you to judgment, and there's just nothing there for damages. If all you have to do is say a dollar amount on an income-based case, not on emotional distress, but on lost income, if you don't have to say anything about how you get there, then the disclosure rules are completely superfluous.
He was not deposed?
That's correct. He was not deposed. No depositions were taken, Your Honor.
Okay.
Why? Why didn't you depose him? Why didn't you ask him questions?
But I would also note it's an affirmative disclosure requirement to give a damages calculation.
Happy Friday, 99 Problems.
So you can't just wait for the other side to ask for it. If you're going to be asserting you're entitled to those damages, you have to provide that information.
I love that this is his argument, that if you're gonna say that you have these damages, you have to show X amount of proof, and then he goes to defend his client, which is what he's supposed to do, Laura Owens, and then shows no proof for the same argument.
Out front. And so there's just been a whole entire failure to provide any information that would support damages being awarded at all at an arbitration hearing. And for that basis, both claims have to fail, and the court should dismiss them on summary judgment, as there are no genuine issues of material fact as to damages.
What about the nature? Aren't you also arguing that the nature of the emotional damages are insufficient as a matter of law? That there's no proof of it because of the lost sleep, that kind of stuff?
Correct, Your Honor, correct. That was the second prong that would solely be applicable to the IIED claim. That there wasn't severe emotional distress. That again, the disclosure statement, there is nothing about the counterclaims, nothing about the facts, nothing about what emotional distress was or was not suffered. And in fact, in the declaration that again, we object to, but was attempted to be offered, all that was said was increased stress, sleepless nights, loss of enjoyment of life, and overall emotional distress. So absolutely no details about what that means. And so, Your Honor, on that basis as well, my client is requesting the court to, if it doesn't find that the lack of damages is sufficient to dismiss both claims alone, to at least have the IIED claim dismissed. And that's all I have, unless the court has any further questions about my client's motion for summary judgment.
No, I understand. Thank you.
Thank you. Your Honor, as far as the defendant's motion for summary judgment,
Well, maybe the better way, I know I directed you to do that.
Also, these cameras make it look like it was shot in 1975. It is it is throwing me off.
Maybe the better way is to go back and forth because they're two separate areas of fact. So let me just do it that way. So you can respond to the motion. That's fine, thank you.
Is there a way to move this over, or?
I think-
It feels awkward speaking this way when you're over here, Your Honor.
Joseph, does that move?
Perfect. So, Your Honor, I think there's two different distinctions between a fraud claim, where you can recover consequential damages, and a IIED claim, where you can recover general and special damages. Defendants conflate both of those two. The initial disclosure statement and supplemental disclosure statement, they do state that there is a $50,000 pertaining to the fraud claim, and there's also severe anxiety and emotional distress pertaining to the emotional damages for a claim, which we call the general damages claim and the IIED claim. So there's a distinction between those. So we did disclose the damages. It's not an issue of they didn't raise the issue that we didn't computate damages with a reasonable certainty, because we did on their case, on our motion for summary judgment. So I think that's a fine distinction. So to the extent the court wants to dismiss a case on the damages portion, I would respectfully ask the court to look at the disclosure statement. We did bifurcate those claims, whether it's
Let me take a look at that because I'm a little, it's the,
Auntie M, hi, thank you. Thank you. Auntie M just just gifted 5 gift memberships, wishing everyone a lovely weekend. Toadette, Say Cheese, Ellie B, Miso Dynamosa, Lisa White, and Kiki Knows. You guys all have memberships. Welcome. I hope you guys enjoy your new benefits. Thank you to Auntie M. Thank you, Auntie M, so much. Ooh, which also means it's a new month. I get to give out. Wait, I get to give out stuff. I'll do that at the end. Hello and welcome. Hello and goodbye, everyone. Thank you, Auntie M. I need to give out some memberships, so I'll do that. Strike 1010. We're keeping track here.
It's in the supplemental disclosure statement, Your Honor, and I will state that my firm came on board just 2 weeks before the arbitration hearing, so we're going to cycle what we got.
I'm looking for something that's in the, not, it has to be in the record before me. Isn't it included in the,
It's in their response to the motion,
That's what I'm
sorry,
saying.
their motion for summary judgment, Your Honor.
all right, let me find it. It's in whose response though? In the plaintiff's response?
Plaintiff's response, Your Honor, yes. I think they attached 1A through H, one of those exhibits.
Pulled up the wrong response, yeah.
Also, where is Laura? Like, why is she not on a screen somewhere?
And it's your supplemental disclosure statement?
Yes, Your Honor. And I just want to clear something for the record, Your Honor. The plaintiff's counsel referred to my client's declaration as a disclosure statement. It's not a disclosure statement. It's an affidavit that's used to support a summary judgment motion.
I
under Rule
assume that's,
56. Yeah.
I think I understood that. I don't remember precisely how he characterized it. So all I see as exhibits is the affidavit of Laura Jones, which I read, and the controverting statement. Is it attached to the actual, it's a response to your motion for summary judgment?
And Your Honor, may I approach the bench? I have it here.
Sure, I'd like to see it. And you agree you gave this to me?
but what is the title of that document, Your Honor?
Defendant counterclaimant Gregory Gillespie, second supplemental Rule 26 disclosure statement?
Yes, Your Honor. That is attached as Exhibit A to, I believe, our statement of facts in support of our motion, my client's motion.
Oh, it's in support of the motion, not a response. Okay.
Not in response to
I was
their
looking for
motion.
a response, my mistake. Well, you can have this while I pull up the document I need.
If you pull a case, you should have to come in. You should have to, if you require one party to be there in person, you should require the other party to be there in person, unless there's, like, for something like this. It's just my face. Oh.
Okay. And what do you want me to look at in here specific?
The computation of damages, Your Honor, it's typically section
Good point,
6 or
Angela.
7.
Broccoli, if you're in the Discord, it does that. I don't know. Oh my God. I'm sorry, Jane. Yeah, if you guys are subscribed and you press the notification bell, it should notify you. If it doesn't, and you can get a hold of our Discord, I usually send out a thing on then or on there. I've been trying to upload it on Instagram. I post it on Twitter just to make sure everybody, because I know their notifications are not great.
Damages. Seven, where it says Mr. Gillespie has sustained significant monetary.
This is a great point. If Laura would have shown up, she would have had to wear her fake baby bump because she was just sporting it a few weeks earlier. And she'll find out then she's no longer pregnant, quote unquote, 11 days after mom doc. Ville-Marie said the same thing. She didn't want to wear the baby bump in public. And it's interesting after you're going after this man for abortion coercion and then you wind up pregnant. Right.
Damages as a result of not being able to work due to the extreme amount of emotional distress he experienced while becoming subjected to plaintiff's fraudulent representations and the intentional infliction of emotional distress.
Yeah, Your Honor, and like I said, we filed an affidavit, which we need to do in support of Rule 56. The case was handed to us as, when we got it. 2 weeks before.
You do great with notifications. I just want to listen, I'll just come into your house and rip the blankets off of you and be like, and then I'll do what my mom did in 8th grade and just squirt me with a squirt bottle. And I'll just be like, it's time for stream.
Arbitration. I see that there is a computation of damages for the severe emotional distress claim.
Where's the computation? That's what I'm looking for.
Well, that's what I'm saying, Your Honor. In the affidavit, we submitted that for Mr. Gillespie's.
That's in your response?
Yes, Your Honor.
Okay, that's my mistake, because I thought it was in that document that you referred me to.
I didn't even think about that. I thought that was November 2nd. This is November 9th. Was it November 8th? It's wild to think the day before this was when Deandra grilled Laura at the IAH hearing. Yeah, this judge,
And I have it here, Your Honor, if you want to, may I approach?
Yeah, I'm sorry I'm not able to navigate as quickly through this as I should.
Greg's like, can I bash my own face in with this thing? Look at him. He's looking for coffee. He's like, how do I get out of this situation? What's in this coffee container?
Your Honor, so at minimum, we've disclosed at least damages for the intentional infliction of emotional distress claim. We recognize that the fraud claim, I'm not arguing that we didn't plead fraud.
I mean, it doesn't even matter if it was on the 3rd. The fact that she got drilled by Deandra on the 2nd and then 5 days later, she's doing this shit. The point still stands. You still make a great point. Hi, Frida.
Particularity, but to the extent the court wishes to dismiss that claim based off of lack of disclosure of damages, we've at minimum attempted to create a genuine issue of material fact on doing an affidavit. But for purposes of the emotional distress claim, it can't have it both ways. They're saying that they lost sleep, anxiety, depression on their motion, but for purposes of the response,
Hi,
we
Malin.
provide sufficient information and disclosure statement to compute general and special damages, which the trier of fact determines if that what amount that is. That could be a nominal amount of $1 or some other number, but we believe we provide sufficient allegations of damages of emotional distress to survive summary judgment on that claim.
Well, here's the thing, though. She can't get abortion coercion if she didn't have an abortion, right? So if she shows up pregnant, then it's not abortion coercion. So she's got to die on that hill. Laura appears in court more often than Harvey appears on TV. Good morning, Jack.
Thank you, Your Honor.
Counsel?
Thank you, Your Honor. I think a couple things I would just like to note in rebuttal. Number one, $50,000 is the maximum you can get in an arbitration proceeding, mandatory arbitration. It's up to $50,000. If you're trying to get $50,001, you have to indicate that this isn't appropriate for mandatory arbitration. But both sides have certified their claims are $50,000 or less. This declaration of Gregory Gillespie says, I would have earned nearly $50,000 in commissions, not for emotional distress, but in commissions.
Hi, barbecue.
So if it's $50,000 in commissions, you can't seek an additional $1 for just emotional distress.
You can.
But you can't be.
The judge, actually, you can. You can do that. Has anyone ever heard about how Greg found out about Clayton? So I believe it was his fiance, or she was his girlfriend at the time, but they're married now. She found out about the story with Clayton, and she was the one who reached out to Clayton on Instagram and was like, "You are not the only one," and then gave Clayton all the information about Greg's case. Does anyone know how many times Lo has called the police about Greg? Oh, I can't give you an exact number. I know it's more than 3, but also too, she called the police when Clayton and Greg were like being friends, which was a problem for her.
Awarded it because then you're outside of the jurisdiction of a mandatory arbitration.
Bye,
hearing.
AB.
No, but it says that, does it say at least, is that what you said? Read that one statement.
He says nearly $50,000 in more in commissions, and in their argument,
I understand.
it was
$50,000. Your
$50,000.
argument is, as I understand it, it doesn't make a lot of sense the way that could be,
I'm gonna have to ask
there
my
could be a lot in
husband.
emotional damages, if any, correct?
Correct.
Okay.
If they were seeking emotional distress damages, Your Honor. But my reading of their second supplemental disclosure statement indicates that it is all based on lost income, not on emotional distress damages due to trauma suffered. And so,
Yes, it is. Yet, you know, maybe the world was right and I could never be a lawyer, because I would be sitting on the other side of this courtroom and I'd be like, that's exactly what we're saying. Like, this is what we're fighting about. Like, what are you doing? Yes, that's what we are talking about. That's what we are doing. He suffered trauma. He wasn't able to go to work. He wasn't able to concentrate because she was bombarding him. She was suffocating him. She was drowning him. Ugh.
for those reasons, Your Honor, the court should grant my client's motion for summary judgment on those claims.
Thank you. Let's go on to your motion for summary judgment.
Your Honor, by way of just brief background, Ms. Laura Owens is no stranger to the court. She's filed no less than 3 cases involving very similar fact patterns.
I know that's right, girl. I know that's right. She is no stranger to the court. I know that's right. Mm-hmm. Yes. I know that's right.
Regarding pregnancies and
I would object, Your Honor, that this is all outside of the filings and outside of what's relevant to this case.
Let me hear more.
It's hard for me to know exactly where the relevance is going to kick in because he wasn't finished, but I will assure you I will not consider irrelevant information. So
Your Honor,
what else did you want?
It's in the counterclaim, and the court can take judicial notice of these filings on its own sua sponte.
How does that relate to the facts of this case?
And Your Honor, within the context of these cases, she's bringing an intentional infliction of emotional distress claim based off of what I call the parasitical claim, and what I mean by that is it attaches to the coerced abortion claim, which is now before the court because it's been dismissed. And I think it's apropos, and the court can take judicial notice of that because she's claiming damages.
He talks a little fast. I'm going to slow him down because I like his point. What a great point.
Distress claim based off of what I call the parasitical claim, and what I mean by that is it attaches to the coerced abortion claim, which is
Parasitical claim. What an inadvertent way to call her a parasite. I like it. I like it.
now before the court because it's been dismissed. And I think it's apropos, and the court can take judicial notice of that because she's claiming damages, emotional damages from this coerced abortion, and it's very similar to the other cases before the court.
The other case that got dismissed?
No, the other cases before other courts in the superior court
This
system.
court dismissed the statutory claim already, correct?
Yes, Your Honor.
Okay.
So,
Are there other statutory claims
No,
in
Your
this
Honor.
case?
no, Your Honor.
Okay.
The only claim that survives that's left is the intentional infliction of emotional distress.
Hey,
I
AJ.
understand
The
that.
case law that we brought before the court states that people usually suffer emotional distress in their everyday lives. But the question is, there is the difference between emotional distress and severe emotional distress. Plaintiffs submitted various exhibits that show a COVID test, conversations between her providers, has never demonstrated or never presented any evidence to show that there is a physical manifestation.
Dirty pop-up ads. Do me a favor, if you guys get those, do me a favor and screenshot them and send them to me, and I will try to contact somebody at YouTube. I don't have anybody, but I'll try to message somebody. Yuck.
Of injuries.
Which is not necessary, correct?
The case law is developing that way, Your Honor. There's no published case in Arizona, but for the most part, there is an unpublished case we cited to that it states that. And it's very persuasive. It's as of 2017.
Doesn't it state that
Hi, Nikki.
that with the manifestation, it just becomes more persuasive, but not necessarily without it, they lose?
Your Honor, well, I think it has to be dealt on a case-by-case basis.
That's what it does say, I agree with that.
Yes, so in this case, what we have here is about 8 exhibits that do not relate to anything regarding her physical manifestation.
virus.
All we have is a plaintiff saying she's been depressed, she thinks about this, the ordinary emotional distress that people would suffer on an ordinary basis.
That would
Last
be great.
minute, they file an affidavit where they never disclose the development of what the distress issues were or symptoms were, and they attach photographs of some rash. There's no causal connection between this alleged rash to the conduct that Mr. Gillespie...
Was the photographs of the rash previously disclosed?
Hi, Mary.
No, Your Honor. Those photographs were never disclosed. We objected to those in our
Right.
reply.
So I really wish we could see the evidence that she put into this courtroom because she has like some weird rash. She's got something on her skin. That's her proof. Listen, no emotional distress. I'm a 41-year-old woman. Oh, I'll be 41 in 6 days. But that's the thing. Any of us could be like, I have a rash. I have a rash. Like, I'm going to ask this question. You all are going to punch me in the face. Are there any doctor reports? Maybe. Hello? Hello? Doctors? Anybody? No? Why? God.
To their controverting statement of fact, or their statement of facts. But, Your Honor, so without the physical manifestation, all we have left was the same exact thing they're arguing that Mr. Gillespie is doing.
Did they refer to the rash without the photographs previous to the motion practice?
Not that I'm aware of, Your Honor. I don't think so. These photographs came up literally to rebut, or to what I view as to create a genuine issue material fact. Because we've told them, we said we need a physical manifestation of injury. So these photographs came up, but even if the court were to consider the belated disclosure of the rash.
See, I just heard that sentence coming from the other side, but go ahead.
Exactly. So even if the court were to consider that, there is no causal connection between the conduct that's not before the court, because that claim is no longer there, and the physical manifestation, what she's portraying as the rash. So, Your Honor, there's no expert opinion to opine on that. It could be caused by something unrelated, and which is why I asked the court to take judicial notice of these other cases.
Exactly. Who needs doctor reports when she can give you the login to her patient portal? I'm so tired.
She's been doing the same thing to other individuals, and that's public record, Your Honor. So even if we get to the physical manifestation, which there isn't because it wasn't disclosed, but even if there is, if the court does consider that, there's no causal connection traced back to Mr. Gillespie's conduct. And again, Your Honor, the same thing they've argued in their motion, their damages calculation is computed as attorney's fees and costs of $40,000. In tort cases, we're not entitled to recover attorney's fees and costs. So I'm not sure, they're arguing the exact same thing we're arguing in our case. So for those reasons, Your Honor, summary judgment is proper for the 3 reasons: that there's no physical manifestation, and even if the court considers that, there's absolutely no causal connection between the conduct.
Right, because there's no proof. There's no proof ever, because she has no proof ever of anything. Ever.
The alleged conduct to the physical
I've
manifestation.
already watched this. Watching this right now is making my skin itch.
And more importantly, as with any plaintiff, they bear the burden of establishing their claim through a preponderance of evidence. they've attempted to, in their response, they've attempted to place that burden on us, that we didn't raise that, which is not proper. It's their burden to present their damages. They did not do so. They're not entitled to attorney's fees in tort cases. And for those 3 reasons, Your Honor, summary judgment is proper.
No, I put it back down to regular speed for him. The other guy talks a little bit slower. Laura's attorney speaks a little bit slower, so I turned it up for him, and then I turned it back down for this attorney.
Counsel,
Thank you, Your Honor.
are you entitled to use that affidavit?
Rash incoming. Watching this gives me hives.
If it seems like they objected to it, Your Honor, it is a late disclosure.
It seems he's like, me thinks. Me thinks.
I think whatever rules the court applies to both sides should be applied to both sides. So if the court determines that it was too late of a disclosure, that's what we're left with.
And let me just bounce it back to you just for a second. Do you agree with that?
I knew somebody was going to ask me. So I have like a little Ninja single blender. So in here I put 1 scoop of chocolate whey protein with 2 ounces of milk, the rest water, a half a banana, and 1 tablespoon of peanut butter. Delish. And this will be my lunch. So I am on a weight loss journey, only because I have let my weight slip away from me. So I've just been doing more mindful eating. I'm walking 2 miles every other day, and then in between those days I'm doing strength training. Tonight is my day off because I'm going, guys, I'm going to play softball tonight. I have played softball my entire life. Since I could walk, I have thrown a ball, okay? And that was the one thing that I did growing up with my mom, and we played softball every single day. And in my 20s, I was on leagues, and I played 5 days a week. And I haven't played because of the kids, and so I got on a team, and I subbed for them. So tonight I'm gonna go. All prayers, may Dave be with me that I don't break anything. Okay, please. But anyway, so I've been better about mindful eating, getting my sleep. I'll tell you guys more about it. I found this girl on TikTok that was like, hey, if you're 40 and close to perimenopause, let me tell you what you need to do for like some weight loss and managing your weight, because my weight won't budge. So I'll tell you about that. But mindful eating, walking, strength training, and getting my sleep right. Oh, I am feeling so good. So good.
Your Honor, I was stuck with the case when I got it, but I do agree that the computation of the fraud.
Well, I was just, and I'm not asking in any gotcha type way. I'm asking more whether there's any distinction between the one later disclosure over the another, and it doesn't sound like there was, correct?
For the
Thank you,
fraud claim,
Wallace.
it wasn't disclosed, and that's what I'm saying, but, so I agree
You're
with
in
you.
the same boat, the other direction. Okay, go right ahead.
Right. Your Honor, the only distinction I guess I would make with regards to my client's disclosure is what Mr. Zazueta noted as far as the failure to disclose any legal claim regarding physical manifestation of symptoms had to be shown. Because as I indicated in our filing, if you look at their disclosure.
But that's just a matter of what the elements of the case are. It's a legal issue. The point's taken, I mean, is well taken, but understanding the question of the legal standards, I'm not quite sure that's a legal theory, but I understand your position.
Sure. Thank you, Your Honor.
Hi, Julie.
And let me back up. One other thing that I just wanted to note for the court as far as the defendant's motion for summary judgment is that, so their prong is, absent a manifestation of physical symptoms, plaintiff cannot assert a claim for intentional infliction of emotional distress. As the court is aware, in order to be successful on summary judgment, you have to initially prove that you're correct as to the law and facts. Here, the initial prong was, because there was no manifestation of physical symptoms, we cannot be successful on intentional infliction of emotional distress. But that's not what the law of Arizona says. So one of the issues with their motion as well is they failed to meet their burden of showing that there has to be a manifestation of physical symptoms, because that's what they alleged in their motion. And in their reply, it seems backtracked a little bit to just overall.
And what you filed was the fact that you have to show how you got there. All she says is, I have a rash. How did you get there? Oh my God.
No severe emotional distress. But the motion itself was all about absent a manifestation of physical symptoms, plaintiff cannot prevail, which is inaccurate. And so my client would argue that.
I've already watched this, so my consensus on this judge is I like him up until the end. I struggle because I guess it's hard with the time that they have in knowing this case. You know what the judgment should be. Do I think he did what he could with what he had and just said, both of you are done, nobody's getting paid? Fine. So it didn't cause Greg Gillespie any more money? Do I think that Greg deserved that? Absolutely not. I think he deserved to get money from Laura. But I also think he has to preside and give judgment over the case that's in front of him. And that really depends on what the lawyers bring forth, you know? So I just think it's complicated.
They had failed to meet their burden.
No, she's
and
not.
so the burden never comes to my client to rebut that motion for summary judgment and to provide a genuine issue of material fact because they failed to meet their burden initially.
I have to tell you,
Hi,
you lost
Kim.
me a little bit on that.
Sorry, Your Honor.
That's okay. Their burden in the motion for summary judgment is to demonstrate an absence of material fact. If they meet that burden of production, under the standard of proof, which is by a preponderance, then your obligation is to point to or produce evidence that shows where the question of fact is, correct?
That's correct.
So the argument I hear you making is that because they relied on the absence of physical manifestation, that's enough. You don't have to then point to any evidence because they've not met their burden of production of proof, correct?
That's correct, Your Honor, because that.
But then your burden of proof is a picture of a rash that she has. Do you have the picture of her whole body? How do you know it's her? How do you know she didn't take that rash off the internet? How do you know that rash isn't from her sister or her mom or her dad or whatever the case is?
That's
what they relied on. That's what the motion was based on.
Isn't it also based on I thought I read in there, it was also based on the nature of the injuries, not, because they're connected.
They are somewhat connected, Your Honor, but if you read through.
Alleged anxiety, loss of sleep, that kind of stuff, correct?
Yeah, and how do you show for that? How do you show when Greg can't go to work because he has this bitch bombarding him all day long? How do you show that he has heightened anxiety because she texts him all day long talking about a baby that he doesn't want to have with her? How do you show that he is, not being able to concentrate on doing his job because this bitch is calling his work? I mean, that would have been the biggest thing is if they could put the text messages forward and the emails for the judge to see, I think that would have changed a lot because there's so much from her and less from him. But I don't know if they could admit that stuff in court.
And if I could just have one moment just to read this section of their motion,
Sure.
Your Honor.
The only reason I'm parsing it is because I need to understand what your position is.
Correct.
Again, this is a great question. My question is, if the abortion coercion was dismissed, which is the main claim, how is her claim for emotional distress surviving if the initial cause of action was dismissed? Great point. Because this is our fucking legal system.
As I read through their motion, and this is subparagraph B, which is entitled, absent a manifestation of physical symptoms, plaintiff cannot assert a claim of intentional infliction of emotional distress. There is no argument in there that.
If you give me anxiety, which causes me to throw up, do you want me to bring it into a bucket into the court? And I know that anybody can say emotional distress, right? But when you have the text messages and you have the emails to back it up, I mean, the judge could easily read through the time. She is just rapid fire texting. And when she's not texting, she's emailing. And when she's not emailing, she's calling all day long.
The actual emotional distress alleged was not sufficient. What they argue is solely throughout, they cite to one case and say courts have observed that mere emotional distress and severe emotional stress should be demarcated.
Great joke.
Indicate as a result of crying, being upset, that is not enough to establish severe emotional distress. But other than these two quotes or citations, the actual argument itself is all based on physical manifestations.
Okay.
As far as the damages issue, Your Honor, as I mentioned in argument regarding my client's motion on their claims, income claims and damages from a lost income claim and damages from the trauma suffered due to emotional distress are very different, because there is no lost income which can be easily demonstrated by a paycheck when you're talking about trauma suffered by emotional distress.
What if there were a leave of absence from work and they go on family leave or anything? Not that happened in this case, obviously.
Right,
I mean,
but
it can be tied specifically to money, right?
it can be if that is what the claim is for.
Okay.
Here, it is not for lost income or things of that nature. It is for solely the trauma that was suffered. And I admit the wording was unartfully phrased in the damages section of the calculation, but it does state, and if I can pull it up here.
Am I going to be looking at your response or their
I'm
original
looking.
motion?
Thank you, Your Honor. I'm looking at their exhibit. So it is my client's disclosure statement.
Okay, hold on a second.
And you're right here if you want to see.
I think I can, I know I have no credibility in my ability to go through this. Yeah, I'll take a look at it if you have it. Sure. Thank you so much. Okay, I'm looking, what page?
And we're looking at page 5, Your Honor, under subsection 7, computation and measure of damages.
Okay,
And so the second sentence in that computation and measure of damages indicates it is anticipated that damages will amount to at least $40,000 due to the trauma that Ms. Owens suffered. I admit that first sentence is, the combined effect of them is unartfully phrased, but this is sufficient to put them on notice that my client was seeking $40,000 due to the trauma suffered, not just due to cost.
Sorry, my chat stopped working. I don't know. Sometimes when I pop it out, it just stops working. So sorry. And there's like no way for me to redo it. That's so weird. It just stopped. Anyways.
And fees associated with the
what are
case.
costs and fees?
The cost would be court costs and attorney's fees. And attorney's fees are not recoverable as a matter of right in a tort case. And I agree with that contention that they made in their motion.
Hi, Ken.
But essentially, an and, or additionally, it is anticipated that it'd be $40,000 should have been added into this to make it more clear. Although I think when somebody says $40,000 due to the trauma that she has suffered, that's not just based on costs that have been paid out of pocket. And so
Costs could, not here anyway. We're not talking medical bills, those sorts of
That's a good point. He did say that he went to therapy. He did say that he talked to a therapist. That is such a great point. They should have brought that in.
things.
Correct.
I bet you she wouldn't have that.
that is not what is being sought. The only thing that is being sought at this time, and that would be sought in an arbitration hearing, would be damages for trauma, general emotional distress damages, rather than associated with any specific cost or expense.
Okay. Reply? Anything else?
No, thank you, Your Honor.
Your Honor, I'll just touch up on the damages portion of it. It was pled as the complaint says that she's seeking attorney's fees and costs, which is consistent with the initial disclosure statement.
Let me take a look at the complaint. It's in the complaint.
The complaint states that she checks off the box if she was pro se when she filed this.
Oh, that's right. They're pro se file.
This pro se filing, defendant or plaintiff's counsel could have supplemented and elaborated more, at least to argue and said you're seeking general and special damages, which are the damages recoverable in injury cases. That's not pled here. But I don't think we get to that point because they don't meet their threshold to show that the emotional distress was severe, let alone they don't show any physical manifestation. It appears that the plaintiffs are arguing that we've waived the argument that there is no severe emotional distress because it's in a reply, and I think the court considers all the briefings.
But I think, candidly, it's inextricably tied to the question of whether there's a manifestation of harm. You're talking about the nature of the harm. Okay.
I agree, Your Honor, and there's no physical manifestation.
Right. You're talking about the nature of what happened. How did we get here? We got here because she's psychotic. Ta-da!
But the injuries that she's claiming, there's no causal connection between the conduct that's alleged. That
I
comes
don't
up
know,
before the
Kenny.
court. All of these symptoms were stated in conclusive fashion in the complaint pleading stage, but throughout this entire case, nothing's been elaborated, and it's been, we don't know if the court, and we can't determine if this rash is a symptom from Mr. Gillespie's alleged
Exactly.
conduct. She could have a scratch or bruising, and she can say that's tied to the conduct. I mean, where do we draw the line? I think.
Was there anything in there about the date of the rash, when the rash was?
Still, what does it matter? What does it matter? If he told her to go fuck herself and she went and rolled in poison ivy, what does it... Oh, my God.
Or is it just a picture of a rash?
It was a photo of a rash, and I will note that
It says it has a time period on it, right?
I believe
Does it? Does it? Or did she fucking Adobe Acrobat that too, Your Honor? See, I could never be a lawyer. I'd be kicked out immediately. Oh my God.
Yes, Your Honor, but I note that we objected on the foundation because her affidavit does not state that photograph accurately depicts what is being demonstrated. So it's a foundational argument we raise, and I think the court, it's an objection that the court will, in my opinion, should consider because there's no foundation for that. But again, Your Honor, there's no physical manifestation. The case law is developing. I concede that point, but the most recent unpublished case that we've attached says that...
The 2017 case?
Yes, Your Honor.
Yeah, I read it.
And in that case, Your Honor, the court cites two various cases and it says, well, typically in our cases, everyone suffers emotional distress.
You understand that case hurts your other case as well.
And again, Your Honor, at the end of the day, if the court were to dismiss both cases, that would be a happy day for my client. It's been 2 years.
That's what I'm going to do, folks. There's not enough evidence of emotional harm from either side to survive summary judgment. So you're both right and you're both wrong. Class half empty, class half fill. I'm going to sustain the objections to the late disclosures. I'm going to grant the cross motions, both cross motions, for summary judgment. I further find that the damage disclosure made by the defendants in the case with respect to the fraud were insufficient in and of itself, and were insufficient for both the claims as well. And I find that the damages disclosure with respect to the plaintiff's claims, following the court's lack, because the court, in addition to the court's failure or decision that the late disclosure will not be considered, is also inadequate. Even if I were to consider both those filings, frankly, there's just not enough there for the court to find that it meets the standards of, and I looked at Midas Muffler case that you folks provided me. That seems to be the more, it's published court opinion, and it tells us what we need to be looking at. I will, who wants to give me, can you just work on a joint form just as to the form of judgment to the court? I'm not going to be granting, well, I don't know whether you want, I'll tell you what I'll do. I'll have you submit one with respect to the claims that you prevailed on, which is your motion for partial summary judgment. You submit a form of judgment, both of them in 20 days. Any statement of costs or applications for attorney's fees will be due at the time that you lodge them. I'm sorry that you folks, both sides, have endured a lot in this case, and I mean that respectfully to both sides, that these kinds of events can take on a life of their own, and they create dynamics that are just not addressable in a judicial proceeding. It's not going to work here. Is there anything else for today?
Nothing further, Your Honor. I appreciate the court's time.
No, thank you, Your Honor.
All right, we're done.
Okay, so this is done. Let me, now that I've watched it a second time, let me just say this. I think, look, guys, obviously it's very clear how we all feel, right? We know that money has been stolen from Greg. We know that his time has been stolen. We know that she fraudulently brought this into court. However, it's not what you know, it's what you can prove. And do I think, now looking back on this and watching this again, that this was the best outcome that Greg could have gotten under these circumstances? I do. Because the only other thing was that she would be able to prove it and he would have to pay her. And now it's just been dismissed with prejudice. She cannot come forward with this ever again. Do I want to see a world where Laura Owens gets punished and, Greg Gillespie gets his money and she has to pay that? Absolutely. Do I think, now watching this in hindsight with a better understanding of everything going forward, that the judge did the best he could with what he had? Also, yes. Does it piss me off and make me itchy? It does. It does. And it sucks. It sucks. Yeah, his aunt was pissed. Laura took it there. I feel so bad for Greg. He had one overnight. Right. Is me spiritually? Oh God. Okay. So what we do know now, though, is because somebody said, I believe it was no thanks. They said, how is she not getting jail time? We'll know more about that on the 26th of the month. So the plea deal deadline is the 26th, which is a Friday. And we'll either see the fact that she's going to trial or she has a change of plea, and then they'll have a hearing, a complex case management, which is basically a status hearing, and that'll be on the 29th, which is that following Monday. Obviously, we're all hoping that she goes to trial. That's my hope. Oh, go to trial. Go to trial. You made a sandwich, Bruce. Go to trial, Laura Owens. We believe you. You're a victim. Do it, do it. Go to trial, Laura Owens. Tell your story. Write a blog. We don't care. We just want to hear it. Tell your story. Do it, do it. Hey, yeah. Go to trial, Laura Owens. We believe you, Laura Owens. It sucks. It sucks. I think I think he did the best with what he had. And that's the thing too. You look at things like Casey Anthony, not what you know, it's what you can prove. You look at things like OJ, not what you know, it's what you can prove. And it sucks. It sucks, but also with that being said, as somebody who could be somewhere in the legal system, you have to look at it from that standpoint too, as people who could be in legal proceedings, and that's what you want, right? If you are sitting on the side of court, you don't want them just to be like, well, this is what we know. No, it's what you can prove. What can you prove? Hard facts. And that's the hardest part. My chat keeps... All right, I'm going to stop popping my chat up on stream because it's pissing me off. Because it does not want to work today, and it's making me very upset. So I don't know what's happening today, but we are going to move it, and I'm just going to have to read it from here, and that's going to be it. It's just so much perjury. It's all the perjury. I just arrived immediately with go to trial. Hey!
My soul needed that dance.
That dance. My soul needed that dance. Did Greg spend $100K on defending her assertions and lies? It was one date. Greg has spent over $300,000 on Laura Owens. I agree Greg would have paid way more to prove his damages with an expert. It makes me dance. Every time you do that song and dance, I laugh and smile. Yay! Yay! We want more BS medium blogs. Is that an elbow cough? Yeah. Why is everyone elbow coughing at the dance party? I'm gonna keep trying to pop out the chat so that I can see if I can use it, but my chat is being so weird today. I don't know if it's the internet. I don't know what's going on. But with that being said, all right, let's see what we have now. So we had the hearing. And then multiple filings made in the abortion coercion case. What is that? That's December? Oh, no. We did that already. Okay, so then we go here. So now we're in the land of 2024, okay? So, Dons. Let me see here if I can get these chats. I wish these chats were global here. Bruce is still stuck on the screen. There we go. Let's see if we could do this. Please work. And then if you don't, I don't know. We'll figure it out. Call member checking in. Hi, LM. Okay, so then we have February 16th, Judge Michael Gordon submits a judgment ruling in the case that it's dismissed, with both Laura and Greg needing to pay their own fees and costs incurred by this case of abortion coercion. On April 21st, Greg Gillespie emails David Gingras after Gingras expressed interest in speaking with Greg. Oh, right. This would make sense now, the crossover. So Gingras, I believe, starts in March for Laura Owens, and then he starts wanting to talk to Greg and Mike because he's representing her in the Clayton Eckerd case. Yes. Bacon mods and chat. Until next time, take care. Thank you, Malin. Thank you. Also, no thanks. Thank you for that super chat. I appreciate that. All right, I'm not going to highlight chats on my screen because it's doing something bizarre and I don't like it. Greg states that he does not want to air everything out on social media, further stating, I am a normal guy with a normal job and fixated on being a new dad and my normal life. Aww. He further states Laura tried to ruin his life with the abortion coercion lawsuit and that the story is so similar to Clayton's. They emailed back and forth about the possibility of speaking, how Laura has conned Greg and Clayton paternity cases. On April 23rd, David Gingras states he's blocked Greg Gillespie's numbers. Why did he block the numbers? All right, I've never seen these emails. Let's go. Also, guys, we had a conversation. We know that David Gingras is going through a rough time. I'm not here to shit on a man when he's down. So all we're going to do is read the emails. I'm going to keep this very matter of fact, right? It's a part of the story. I'm not going to stop talking about the story. We have to get through it. But we're just going to keep any part with David Gingras moving right now. So this is from Greg Gillespie to David Gingras. Thank you for continuing to entertain me while you and Laura are just further exposed. Daddy tell mommy on Gregory. Again, LMAO loser. What is this in response to? What is this in response to? Oh my God. It's so weird that she was able to time all of these pregnancies so that she wouldn't have a court date about another person's DVRO while pretending to be pregnant. Wait, it's so weird to me that she was able to time all of these pregnancies. Oh, yeah. I see what you're saying. Okay. Yes, I agree. She had multiple claims. Shenanigans are out of control. She doesn't and does know, never felt consequences ever that I see. Shut all up by taking down videos and holding DVROs. Shame escaped too. Greg Woodnick was so smart in pointing out how content creators did investigative work worth hundreds of thousands of dollars. Yes. So this is police redacted. What is this? Oh, on 6/11 on my birthday? Shut That's me on 6/11. Holler. It's happy birthday to the bacon. Or is that 6/1? Because this is, oh no, June 11th. I get a birthday thing? Look at me. What do I get on my birthday? It's a department report. It's a police report. Owens claimed that Clayton Eckerd, Michael Maricini, and Greg Gillespie all violated her active orders of protection against them. The incidents occurred on multiple occasions as detailed in the report and awashed documents. On 6/11/24, I was wearing, okay, so he was wearing his uniform. Interview with Laura. I then called the something Patty, who identified herself to me verbally as Laura Owens. I asked Laura to explain to me what happened. Who typed this? And were they under duress? Laura explained to me what happened was, and then following is what SM told me. Oh my God. Happy early birthday. Thank you. I will be on stream for my birthday. I'm going to see if some other creators want to come on a birthday stream with me on Friday on the 12th. She explained that on 6/11, 3 different men whom she has an order of protection against all came to town to conspire against her and create a smear campaign. She stated that she was in court on the 10th and that Michael Maricini violated her order of protection by appearing as a witness in the court hearing where she was asked to testify as a witness. She stated that the judge presided over the hearing knew about the order of protection and allowed Michael to testify and stay in the courtroom, which means he then did not violate the court order. She stated that her attorney told her that this posed a significant threat to her safety and well-being and that it violated the strict no contact rule in the order. To quote her further, Judge Matta allowed Michael Maricini to slay allowed Michael Maricini to let me highlight it right here. Oh wait, can I? I can. Hold on. Allowed Michael Maricini. Fuck. I need a highlighter. God bless it. Is it pen? Highlighter? Wait, highlighter? Allowed him to slay despite my restraining order. Slating judicial branch security will ensure the safety of all parties while at the Northeast facility. Additional accommodations will be considered as requested. This statement does not justify the violation of my protection order as the presence, good Lord, of court security does not replace the legal protections granted by the restraining order. She stated that the hearing was related to a paternity case against Clayton Eckerd, whom she also has an order of protection against and is also guilty of violating her protection order. Oh my God. Conspire against her. Happy early birthday. My husband's birthday is tomorrow. Yay! Happy birthday! 6/6/1960. This is the complaint. They got together because they were testifying against me. What a dumbass. Keep on trucking, exposing the gal's lies. That's why we're here. They broke my order of protection because they were witnesses. Also, you have an order of protection against them. They don't have an order of protection against each other. They can literally hang out. It does not say that they cannot hang out with each other. Laura then, oh God, I can't highlight. Laura then sent Milo an email detailing how Clayton Eckerd and Gregory Gillespie, she also has an order of protection against because you gotta catch them all, has violated her orders of protection by indirectly causing their substantial following on social media to harass her. Okay. She states that Clayton has appeared on multiple podcasts saying about Laura she is dangerous and she needs to be prosecuted. Where's the lie? It should be noted that she could not cite... She could not cite and instance. What else? What is this writing? Any of the 3 males asked... Okay. She could not cite where any of the 3 males asked her followers to harass her. Laura slates that Gregory violated his order by posting his woman. Ugh. No one should cave to her harassment. She is dangerous. Laura stated that these posts and comments on podcasts are violations because these statements are untrue and defamatory in one re. And I feel like I sound like a sim. They incite their followers to further harass her. Laurel and cities. From one of the order of protections, defendant shall not communicate or postle untrue or harassing comments regarding plaintiff online, including but not limited to on social. What on earth is going on with this document? I know. I don't know. I don't know what's happening. They broke my order. Yeah, I don't know. But here we are. Ugh. So there's that. Okay, let's go back here. Yeah, I also, it's funny if she were to ever like say that about me. I never incite anybody to, go be hateful or go be, violent or do anything. I just like to talk shit on the internet, and we like to talk shit here as a group. Oh my God. Speaking in tongues. He types like me on a flare day. It's just, I sound like I'm speaking Simlish. It's so funny. It's giving grandma texting after doing wines. Oh my God. Okay. So then is Greg Gillespie wrote, looks like I'll be owning a new horse farm 3.1 miles away from my home. Greg Gillespie. Oh my God. The fact that she has 3 OOPs against 3 different men that want absolutely nothing to do with her is crazy. I would be too embarrassed to call the cops over and over again. It makes her look bad, not them. We'd all write funny if he had to spend time listening to her. That's true. That's true. I just watched the virtual juror contribution. Wow, it is so clinical as it dovetails everything back to 2014. I only got through some of that. I started watching it. Oh my God, I've been sitting here in the live for over an hour and it just never started for me. I close YouTube, click on the live, and still starts in, oh God. You know what? There's some weird stuff happening today. My chat is being weird. Yeah, Greg is such a savage, yeah. Okay, so then this is from Gingras. David Gingras wrote, what is this? Look at this. Just so you guys know I'm not crazy. Okay. If you are up late, just call my cell on WhatsApp. I'm out walking for the next hour, but tomorrow is fine. From David Gingras. Greg Gillespie. R.E. Eckerd. Call wouldn't go through. You must still have me blocked from when you chickened. Rather than just unblocking or unlocking, you likely need to delete the contact entirely after unblocking and then save the number as new. I have experienced in this from having blocked Jane Doe's 14 different iMessage accounts she contacted me from, then had to unblock to connect after her threats to my family and workplace. Greg Gillespie. He's like, I know how blocking works. Hoboken. Hey, we aren't being weird. No, not you. The technical side. Jan broke his brain. Wouldn't it be great if when the house goes up for bankruptcy, all 3 guys bought it? I don't know. I don't know if I'd want that. I'd need to sage it to the ground. So proud of the virtual jurors video. Glad she hopped on the madness train. Yes. We are all Greg. We are all Greg. Let's see. This is from David Gingras. If you really want to talk, I'll do it. I'm not the asshole you think I am. Oh, up here. I told you I was happy to talk. You're the one who chickened out. If you really want to talk, I'll do it. I'm not the asshole you think I am. Then Greg. Call me sometime. We can talk through it. Then David Gingras. What did I lie about? Then Greg. Plenty. But your display on Monday, the liar you chose to continue to defend, that is a choice, not your job. I want you to know that I know that. You have also lied. You're very, very bad at this. Greg Gillespie. Gingras, taking the time to email me. Don't you have better things to do? Guess not. Sad. What am I reading? What am I reading? I want Bacon's input on the virtual jurors' input. It goes back to 2014. We should do that. Yeku actually said that we should do a collab. I'm always up to collabing anybody. And that's when Greg hacked my heart again. All right, let's see if I can. I'm going to keep trying to pop out chat, but it keeps not working. So, and I don't want to keep doing this. But also, I like having my chats on the screen. It makes me so mad. All right, David Gingras. Hey, loser. This is to David Gingras. Hey, loser. Glad it didn't go your way. Like in any way possible. LMAO. Enjoy your trip. You know, I think a new city for you might be a good idea. Greg Gillespie. Greg is exactly who I would be. Exactly who I would be. Oh my God. This is from David Gingras to Greg. If you recall, I was the one who was happy to talk last week or whenever you reached out. You're the one who got scared and decided you didn't want to talk. If anyone needs a welfare check, it ain't me, bro. These two are having just like a dick showing contest right now. I'm still here, happy to chat anytime. Friday life is good. If you seriously care about justice, you'd talk to me. I am probably the one person who is in the best position to be able to do something to help this situation. I have good communication with Laura, and despite what everyone thinks, I remain open to the idea that maybe she has done everything that people claim. Until recently, I had zero reason to believe that, but the texts with Michael Maricini are a concern. Interesting. Not going to deny that, although at this point, since I haven't been allowed to verify them, I can't accept them as accurate. The real problem here, but yeah, see, and this is where I have an issue, because he says that he hasn't been able to verify those, but he wasn't able to verify her ultrasounds and things like that either. Which means with that argument being stated, he wouldn't be able to accept them as accurate. She's got the horror stuff. We were so confused. Oh. Again, this wasn't a ruling on facts of the case. It was on the pleadings. Oh. Yeah, virtual juror. If you ever see this and you want to collab, please let me know. The real problem here is that no one from your side will talk to me. Because of that, I only get to hear Laura's side of the story. So, of course, I accept her version of the story. It's the only one I've got. If you assume I truly am a reasonable and somewhat open-minded person, just imagine what would happen if one or all of Laura's victims were willing to pick up the phone and tell me their stories. That might make a real difference, but since everyone on your side is terrified to talk, that leaves me with Laura's unrefuted side of the story. You can change that if you want, but it requires being a man and picking up the phone. So here's the thing. I personally have no desire to speak to my opponent's lawyer. None. That's why I have a lawyer. So this is from Greg Gillespie, just checking in. Just want to make sure you're okay since you never replied back. Please let me know you are alive. I don't want to have to call for a wellness check. Why is he checking on? Why is this happening? Hey, Gingras, everything okay? I was worried when I never heard back from you today. I figured after the nice words in your previous email, you would want to follow up after receiving the very evidence you believed I was bluffing about. Get what you need? I held up my end of the bargain. Be a man, hold up yours. Greg Gillespie. Oh my God. I'm pretty sure Woodnick's team offered Mike's laptop and they did not decide to do that. It reminds me. Yeah. All right. So this is from Gingras to Greg. People were calling wellness checks on low. Oh, I see. At this point in time. Just FYI, I blocked your number on my phone. I don't have time for games. I'm happy to look at evidence you have that shows Laura lying if you haven't. I've asked several times and you produce nothing. I interpret that to mean you have no evidence. People who have proof don't play games. They lay their cards on the table. Only liars and bluffers won't do this. I've been doing this for 20 plus years and it's always the same. If you have evidence, you show it. If you don't, you throw insults and attacks. Yawn. I'm not impressed. The legal system doesn't tolerate games like this. If you have something that shows Laura is lying, you are welcome to email it to me here. I'm always open to seeing evidence that Laura is wrong. If you prove with evidence, not speculation, that she has lied about anything relevant, I will drop her immediately. I have said that repeatedly, and the offer stands. To be clear, that does not apply to things she admitted to being untruthful about, like the top of the PP ultrasound with Clayton, which is of minimal importance in this case. It's kind of the whole point of the case. It's like the whole thing. The whole thing. People are allowed to make mistakes and admit them. That is not bias to drop them as a client. I need proof that Laura has lied about something that actually matters. And that she has not confessed to being untruthful. Excuse me. As I'm sure you know, Clayton has also admitted to lying in this case. Nice guy. No, he did. What did he admit to lying to? What did he admit to lying to? I'm confused. More name calling, insults, random speculation are not worth my time and will receive no response, so I'm not considering any of that, nor will the judge. I mean, all right, listen. He does have a point, right? If he wants Greg to prove his point, then Greg needs to do that. Minimal importance is not the same thing as unimportant or even irrelevant. God damn it, Jack. You're always so smart. Oh, the real estate deal. Right. I forgot about that. So that's from Gingras. And then this is from Greg. David? May I call you David? Fucking Greg. Greg. David? Can I call you David? That's so goddamn funny. My brain is broken. Is your brain whole broken? Whole broken. First, I would like to hear your response to the important information I have already shared with you in my previous email. I notice you have jumped at the opportunity to respond to a few latter adverse comments, yet you have nothing to say regarding the very important context of my original communication. Non-lawyers like myself would find this sort of thing peculiar. Do you? Please share your man-to-man thoughts before replying to any of the below. This has nothing to do with anything Greg said, nothing really, and it is weird that you think my anger is related to anything other than Laura's actions. It is about what happened to me. It is about what happened to Mike. It is about what happened to Matt. It is about what is happening to Clayton. I read, you said you would quit the case if you found out that Laura was lying. Integrity would be doing that, as you know, she has lied. Instead, you are inciting conflict on the internet, and I think Laura wants you to embarrass me like she has tried with my work, family, and girlfriend. You want a man-to-man talk, so here it is. She has destroyed lives with her, she has destroyed lives with her lies. Be a man and tell her to finally admit she has a problem and that she regrets the lies and hell she has caused because 4 men did not want to date her. You have no idea how horrific it is to be falsely accused of rape and more. You already I'm not, never mind. You already have demonstrated with your posts that you are committed to being the Conor McGregor and winning. Win here is her admitting she faked records and used fake pregnancies to manipulate men, and then she could go get help before more people suffer her torture. Greg. I do not consent to sharing man-to-man manly thoughts. Reporting party. Oh my God. I love the Hoboken. When he realized, right. Okay. This is the day after the Eckerd hearing. Greg is a petty queen. Hi, Kimbo. How are you? He admitted he lied to Lo about sending, right, the real estate contracts. I forgot about that. Okay, so here's from Gingras. Greg, you reached out to me. I have no interest in messing with you. I had no idea who you were as of 3 weeks ago. And when this is all over, I'm happy to move on to other things. You and I do not have any personal dispute with each other. I don't know anything about Laura's past other than what the file contains. None of this is personal to me. I'm only searching for the truth, and I only care about the things that are needed to resolve the legal issues I'm working on. With that said, I don't see any grounds to say that Laura is fucking with me. She's not the one pushing any of this forward. She wants to go on with her life. No, she doesn't. She wants to stay in this loop forever. Forever. No, I know. I need a new mic stand, okay? This thing is like 15 years old and it was like $13 on the internet, okay? I'm gonna get a new mic stand. I promise. I used that money. I bought new curtains instead. I got purple velvet curtains. They come today. I'm very excited. I want to jazz up some of my set a little bit. Go to trial. Do it. But there's nothing wrong with pointing out where things are wrong. Right. She has no interest on dragging any of her past into the present if she does not have to. And she doesn't have any interest on dragging her past into the present because that would work against her. It would never work with her. Her past will always work against her. The only issue I'm worried about right now relates to the situation with Clayton Eckerd. I don't have any interest in you at all, except the extent that Woodnick says you have important information that bears on the case I'm working on. If Woodnick didn't bring you up, I'd have no interest in you at all. If you have important info, then I'm happy to talk. If you don't, then I have no interest in disturbing your privacy. David Gingras. Thank you for the jewels, Leslie. We appreciate the flow state. So this is from Greg. Oh my God. Every time I read, I get the yawns. Ugh. I'll talk, but man to man, I have no problem with putting things in writing. You know Laura is fucking with you, and it's all a lie, right? There is nothing you can do or say to get me to entertain Laura or you. In fact, you're associated with her, therefore you should know my sentiment towards you as a person. Greg Gillespie. From David Gingras. It's Sunday night and I didn't see your email until just a second. Do you want to have a conversation? Despite whatever Woodnick may have said, I am a completely normal guy, and I am willing to have a conversation with you man to man off the record, nothing recorded and no threats. I'm happy to talk now or tomorrow or whatever. FYI, there is an ethical rule that says if you have a lawyer, I can't speak directly with you. I can only talk to your lawyer. I know Woodnick was your lawyer in the past, but I'm not aware of him representing you today. If Woodnick is still representing you, let me know so I can go through the correct channel. Otherwise, my cell is this, and I'm happy to talk with you right now or tomorrow or whatever. Lawyers are not permitted to lie. So I promise you this convo will not be recorded. Will not be shared with anyone and will not be posted on social media or anywhere else. Just let me know. David Gingras. From Greg Gillespie. Okay. Hi, Toadette. Right. This is her life. This is her entire life. Talking about not wanting to drag it. This is what she wants to do. She wants to do that for the rest of her life. Love that too. Purple lover over here. So this side, so I'll show you guys in members like how I have the streaming set up. So I stream this way and then I film that way. So essentially in this small area, I have like two little sets with walls that are maybe like 4 feet wide. This is a closet back here. Eventually, I want to get this built out to just look like a nice closet, but we took the doors off and there's a bunch of shit behind this curtain. So I'm trying to just jazz it up a little bit. Oh my God. Greg Gillespie. To David Gingras. Mr. Gingras, Greg wouldn't accept me your contact information. I'm not interested in airing this drama on social media. I am also a private person, unlike Laura and Clayton. I'm a normal guy with a normal job and fixated on being a new dad in my normal life. You can imagine how upset I was when I was told by people following the Eckerd matter that you may have shared legal papers involving my case with Laura and her pregnancy nonsense on your blog. I have never spoken about my case publicly or shared the absolute hell your client has put me through. None of the other lawyers that Laura had ever did that or treated me with such disregard. I'm sure none of the other lawyers have a blog. You broadcasting my cases with Laura is so similar to her history of contacting my work, emails to my HR, threats to reach out to my employers via Uncle Joe's bizarre emails, having OOP served to my office, and probably more I am not thinking of at the moment. Multiple times to get me to humiliate or get me fired. This feels like an attempt to intimidate me to come to court for Clayton. And if you are about to say that it was the other online people and you were just responding, or that it was not your intention, save the oxygen, as you are insulting my ability to read. Oh boy. It all makes sense in her world. All of it. You have read my file since you've shared some of it, and while Laura and I were intimate one night, regrettably so, times a trillion, this beats her 1,000,000%. It beats it. I did not get her pregnant. The evening was also consensual. I did not rape or orchestrate her rape or whatever that horrific lie was that she told the judge when she was refusing to be on the computer screen where someone could see and visually confirm her pregnancy. Sound familiar? I refused to date Laura or do her relationship contract thing, despite her telling me that she would only have an abortion if I went to her sister's wedding and other crazy demands. It is not just a coincidence that Mike, Matt, and Clayton all have nearly the same story. You should also see the OOP the court granted me prior to getting counsel. It was granted and signed by the judge. Do you think I can read the future, or is it just a miraculous phenomenon that this document lays the groundwork for a nearly identical timeline Laura has displayed between herself and ABC's The Bachelor? She's a lush for celebrities. Have you not seen it? I'm happy to share it with you as it contains our court's seal, time-stamped and dated. Let me know if you feel compelled to see it. Ooh, he's mad. He is mad, friends. And he should be. He should absolutely be mad. Laura tried to ruin my life with her abortion coercion lawsuit for a twin pregnancy that never happened. She claimed she was pregnant in days. She doctored, photoshopped an ultrasound image taken from a website online from years before 2015. Sound familiar? She hid from the court-ordered meetings off camera because she was hiding not being pregnant, and then claimed I somehow was involved in her rape. She even claimed one fetus died because she only took one of the abortion pills. I can go on about the insanity. She tried to ruin my life. She failed, as I have a real child and have been to real OB appointments. Unlike Laura, I'm pretty familiar with how real pregnancy works. How mad do you think she was when Gingras let her read these emails? Oh, God. Oh, my God. How mad. I wonder if, she's had to see them now, but still, I just imagine her being pissed. Her story with Clayton is so similar. Just like with Clayton, she contacted my family and made up connections with my life to make herself feel impactful. She contacted ex-girlfriend based off of one conversation we had on one date and continues to try to connect with them. She sent a cease and desist to my current girlfriend's work just a few months ago to continue to harass me and my family. A cease and desist of what? To stop dating Greg? I demand that you cease and desist dating Greg. Oh God. Standing ovation on my TV room for our boy. Mm-hmm. 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 David, imagine spending a few hours with a human and almost 3 years later that human is still attempting to be involved in your life. I think Laura is maniacal? Ask me on June 10th. You probably realize the same thing, but already got paid and are too far in to turn back after the atrocities you've posted online. Greg, number 2, number 3. I hear there's more. Greg Gillespie. Oh, man. All right. Whoop. Also, if you guys have not subscribed or have liked the stream yet, please do so. It helps get the stream out. Okay, let's go back here. So we have the emails. Okay, so April 26th, a Fiverr logo is found on the ultrasound image. Laura texted Greg on August 6th of 2021 by journalists, some podcaster, Nick Vile, you fuck, Dave Neal, and Megan Fox. This finding was submitted as evidence in the Owens-Eckerd establishment of paternity case. What is this source? Do we need to read this? I don't think so. Let's just get to the evidence. We don't need to read all of this. Get to the evidence, friends. Oh, maybe we do need to read this. All right, we'll go through this in a second, but we'll watch the video first. We've all seen it, but let's watch it again, shall we?
So I can't say with any certainty that that's what it was, but I definitely think she was covering something up there. I think we can say with certainty that blur.
Look, it looks like I'm in here. Hi. In the chats here. Oh my God, look at everybody. Look at all this. Jane Jones, you're in here right now. Who else is in here? I want to see who's in here that's in my chat right now.
Is there for a reason, and I think it was because there was a larger logo. That's what she went in to cover up, but that she missed.
Whoa, that is loud. I'm so sorry, friends. I forgot I had the gain turned up.
And so did all of us. So it's completely reasonable that she missed it. She missed the Fiverr, right?
Thank you for that gifted membership. We appreciate you. Nikki Bobby, you are a member. I don't think I commented, but I was there. Let's see who else is in here.
Yeah, and you got to look at it from a cell phone and you don't see it on a naked eye. What's interesting is she could argue that this isn't hers. She could also argue that, it would be hilarious if she was like,
argue that this isn't hers? She sent it to you. Who'd she send it to?
I know it is. I don't know what's happening.
This was sent directly to me and Clayton, I believe. Steve was the one who received the ultrasound. Now,
okay.
I have hold on, I'm trying to find a document here. I have the metadata. That's right. Breaking news, folks. We have acquired the metadata. Ladies and gentlemen.
The X-Files.
Metadata of the ultrasound used, saying she was pregnant with twins. Not just twins. 18-week pregnant twins? Excuse me. Here it is. What does that metadata say? Uploaded by Janie Dodo Bird. Now, could Greg Gillespie have created a Dropbox account with her name? I mean, guys, what do we have to do? You know what I mean? Show us the metadata. You show the metadata. Well, no, that was actually uploaded by Harvey Weinstein. Like, what do we have to do here to get the final nail in the coffin? And again, date uploaded October 10th, creation date October 6th. So this ultrasound wasn't old. It was created then. I mean, short of people raiding her laptop, short of people, and again, when I say people, I mean federal, investigators. I'm not encouraging anyone to go do this. There's a reason why this codec is there, and we can compare this codec to other proven things she has sent me. And I'm trying to think what else I have from her video wise. I do have other things. If you want to talk with me for a few minutes, I can find other metadata and see if we can compare it to that, because that would prove that.
Let me get this straight. That one is which sonogram exactly? Because
that was
the one
the
that she
video
claimed was Clayton's.
That was the video of the moving twins video. That was
that
the
you put on top. Where did you find that other one? That's what I was trying to figure out on my stream earlier today. Where did you find the original of that sonogram? Where did that come from?
that
The
came from the
Clayton one.
internet. That is a YouTube video. I would have to go down the rabbit hole to find it, but that
It
is a
was a
YouTube.
YouTube video.
Yeah,
Yeah.
that's a YouTube
Okay.
video for sure. And I've seen it. The video
Dave Neal is like my sister's brother, Ham, because she has two brothers from her dad. And one of her brothers and one of my neighbors had a baby. It is so wild. Every time I see him, I'm like, oh my God, you are like these two men that I know. You are the exact same person.
video still exists, and the video was not from a private person. It was from like a medical lab. It was like a
Oh.
their identity even harder to find because it's not from a blog or anything like that. I'm gonna go back to
Gotcha.
sharing my tab here. I'm getting better at this, but I gotta say, I'm no expert, and I would have never done this if it
You're
wasn't for you.
It's a minor. No, it was minor. It's a minor thing because Megan wrote minor perjury song.
You're getting better at it. In StreamYard, it does. I don't know what you were using before. It seems like whatever you were using before worked pretty well as also, but for having guests on, StreamYard is great.
Yeah, I use Ecamm. I still use it for my own private stuff because I don't know, it works for me. But yeah, this is much
Oh,
better.
there's Brad.
So you covered
IT
this
goatee.
yesterday. I guess it's the idea that so when I say Jane Doe can't, when I say she could blame somebody else, she could technically possibly say, "Hey, I didn't when I stole that ultrasound," which I know it's a strategy here. It's a very Harvey Weinstein likes it. When I stole that ultrasound, I didn't know it was from a blog from 2015. I just paid a Fiverr guy for it, or I found it on somebody's portfolio. So chances are, she might have said this. And again, this doesn't make it any better. She might have said, "I don't," in her own head, in her own dodo brain here. "I don't want to buy something. I don't want a paper trail. I'll just steal something." Now, but then again, if you steal it, then I mean, could we find that ultrasound in somebody else's Fiverr portfolio? I mean, it would take a lot of work. But if you start searching
Louise!
ultrasounds on Fiverr, would
Louise comes into my chat.
you be able to find
Look
this?
at these
I don't
names.
know. But I think the more logical thing is that she paid someone to distort it. And that's why the Fiverr logo was on there, because she paid them to distort it.
And if she ever said, I got it from Fiverr, I didn't go to somebody's blog and take it, I'm going to call bullshit because that can't be. Because then how did her attorney come up with the vanishing twin theory, which that sonogram literally came off of a story about a vanishing twin? I just don't buy it. I don't believe in coincidences. Occam's razor. IT Goatee said, Occam's razor. The easiest explanation, the simplest explanation is usually the right one. Statistically, it's the right one. And this is far too complicated. I was listening to Reality Steve's October podcast just this morning on my live. I went back to listen to it because that was the one that prompted her to send him the sonogram. So I went back and we listened to it together, and what a great podcast that was. Steve is just so circumspect and like so straightforward with all of like how, and basically what he was saying was, this is either the unluckiest woman in the whole world, or this is all crap. And it's absolutely right.
You get one, maybe two instances of bad luck lined up, but Occam's razor. I mean, it's just you have to go. And I know a lot of conspiracists like to. Is that a right word? Conspiracy theorists like to. It's scandalous. It does trigger something in your brain to think there's a grand conspiracy. But what we're looking at right here is a fraudulent test and a ultrasound that's not hers, regardless of whether or not she removed the Fiverr logo or not. Now, can I share the most interesting thing with you? I just bought a doula. Doulas are expensive. I'm delivering a baby here. And this doula.
Okay, so this isn't I thought this was the one where they found. Okay, hold on. I thought this was the one that they found the thing. The matriarch. I was there unless it was early because this girl's a night owl. You don't buy a doula, Dave. You hire one. Did Bacon already cover Laura calling the cops on the YouTuber? That's when I joined this mess. I think so. When she did it, she called the cops on Dave. That one should have the Fiverr logo. This was after. Okay, so we're going to skip this. And then we'll go into this. So this is the evidence pretrial statement, evidentiary hearing, 22 pages. We'll get into this. I thought that was the one, but anyways, if you're new to this case, which I don't think you are, but if you are new to this case, they found Dave and Megan, the two people that you saw in that video, had made their own video where they were just kind of looking around the sonogram that Laura had sent to them, and they found an actual Fiverr logo on the sonogram. So there was that. The Fiverr discovery was a long live stream with Dave and Megan. Okay. Oh, Liz Neptune. I haven't gotten there yet. I would love to talk to her too, if she'd be willing to talk to me. Clayton Eckerd provides this pretrial statement for the evidentiary hearing. This proceeding is not complicated, but it is certainly unique given the fraud and circus-style antics from petition. Wait, is this from Daddy Woodnick? Is this? It is. The proceeding is not complicated, but it is certainly unique given the fraud and circus-style antics from Laura Owens. Laura seems unburdened by both science and societal expectations of truth. Oh my God. Unburdened by both science and societal expectations of truth. What the fuck? Hi, BSHN. Can I just call you Bishin? Bishin 2000. Filed an improper establishment petition and order of protection predicated on faked medical records after being rejected by Clayton Eckerd. Laura's medical report, arts and crafts skills have been honored. Oh, sorry. Laura's medical record, arts and crafts skills have been honed over a decade, wherein she falsified records to support fabricated twin pregnancies, forged ultrasounds, manufactured HCG reports, faked ovarian cancer, and feigned having an oophorectomy. She cannot claim that she lacked the intent to commit fraud upon this court when she filed these actions after oral sex and then appeared in court twice, donning what appeared to be a fake moon bump. Laura's malignancy was exposed because she targeted Clayton, the former ABC Bachelor, as her fourth mark. I know. Gets me horny every time. I love how sassy everyone started getting with her. This is insane. Justice for Liz, she got silenced. Oh, it sucks. Yeah. I love how he speaks to her in these. I need to get a bottle of KY. That's what we're going to have to do every time Zaddy Woodnick comes on the screen. Clayton immediately disputed the pregnancy, causing Laura to utilize her playbook, alleging twins, crafting dating contracts, offering abortions, claiming suicidality, and alleging that she was a victim of sexual assault. Laura also contacted the media, which resulted in 3 prior victims of the same pregnancy connecting. I like it. The choice of words in these is great. Zaddy never fails to satisfy. He doesn't. Throwing shade in his official court document is fire. I know. This is great. This is great. What Laura failed to consider was, and you know what? I almost skipped this. I almost skipped reading this. And you know what? I would regret that. Slip and slip over. Hi-ya. What Laura failed to consider was that her claims of being 24 weeks pregnant with his twins and vague miscarriage allegations, including suggesting that twins were reabsorbed into her body, would result in the media she contacted comparing to her known fraudsters like Scamanda. She is a lot like Scamanda. As if unable to stop, Laura continued to commit fraud, including misleading her own medical expert, who impressively calling him a medical expert is wild. Who impressively and contrary to science, appears to have determined paternity without a DNA testing by failing to tell him about her medical history or faked history, including but not limited to ovarian cancer and oophorectomy, as well as the fabrication of the sonogram he reviewed, and perhaps even the July 23rd miscarriage photos. Laura attempts to prevent a full and fair adjudication have only escalated as through counsel, she, per witness Michael Maricini, suggests a witness should be arrested if he appeared at court for this trial. Snail trail. Most of these writings were Isabel. Liz was early on. Now it would be different if she targeted her now. There is so much more evidence for her bullshit. I have to tell you, in the very beginning, I thought I was going to get a cease and desist for sure. For sure. And I haven't gotten one, and it makes me kind of upset, and I feel really left out. So, you know. Further efforts to embarrass Mr. Maricini involved Laura's. Hold on. We have a footnote. In addition to Laura contacting The Sun, page 6, and People, her counsel has made comments about looking forward to reading the obituaries of reporters and about making them homeless. Wow. Ostensibly consistent with how Conor McGregor would act if he was litigating the case. No thoughts. Also, no notes. Further efforts to embarrass Mr. Maricini involved Laura's counsel posting a California deposition transcript from 2018 online. She, through counsel, even tweeted commentary about the case and this court, as well as posted, quote, medical records, contrary to the court's orders. She even mocked Dr. Dean's expertise and expert report and then published it online. Yeah, you're not supposed to do that. Never say never. Straight to jail. She probably realizes there's no point anymore. Did she send one to Melissa Jade? She was streaming regularly, but I haven't seen her in ages. I don't know. She's too afraid not to do C&Ds, or she's too afraid to do it. Yeah, I mean, listen, we've talked about this, right? Do I want to see her take the plea deal? No, I want this to go to trial. So just, everybody can see it in real time happen, and she can sink her own ship for the last time. But also, if she takes the plea deal, I get to talk all the shit I want. And I get to say whatever I want because it's true. But I would still rather see you go to trial. Even in the off chance that a jury finds you not guilty, I still want to see you go to trial and get on that stand. There is no off chance. A jury is going to find you guilty, girl. Guilty. On May 28th of 2024, Laura and her counsel published a joint blog post. How cute. In which Laura made overt claims of suicidality and appears to admit the 2,500 pages of text with Maricini were legitimate and that she never received an ultrasound for her alleged twin pregnancy. Days later, Laura, through counsel, posted parts of the video deposition of Clayton Eckert on YouTube, which I still have not seen yet. We'll get there. The level of inappropriate behavior in this matter is astounding. Laura's anticipated crocodile tears and claims to have been a victim of the media who exposed her cons are disingenuous. Laura's behavior should result in findings from the court in these two causes and may justify a referral to the Maricopa County Attorney for charges of both perjury and evidence tampering. Trial. Porn and cocaine. I flux every time I see you on stream. I just envision you and I in our little boxes next to each other, just going like this. Porn and cocaine. Laura sure was wasting a lot of time and money not going to trial, but then again, right. Just reading low to filth. Yes, we stand. So I was thinking about, what if multiple people came for her legally? Would she be overwhelmed with the amount of people coming for her? I don't know. I don't know, because I think she truly believes that she's the victim. So that would just further support her victim narrative. I don't know. So this is the background. On August 1st of 2023, Laura initiated litigation when she filed her petition to establish paternity, legal decision-making, parenting time, blah, blah, blah. Okay. On August 8th, Laura filed a denied motion to communicate, and August 23rd, a denied motion to compel. On August 29th, a denied expedited what? Condition requested motion to communicate, and on September 14th, a denied expedited motion to seal court record. So, let's see. I was wondering too what happened. She would just use that as as evidence of her victimhood. Absolutely. Hi, Tootsies. Tootsies tidbits. That's so cute. Tweeting on or about May 26, 2024, that Clayton counsel wanted to inflame and bias the judge, and it seems to have worked. Clayton implies he wanted to have sex, but Laura didn't. This YouTube video taking pregnancy test at Clayton's apartment. What are these? Let's find out, shall we? Oh, because it's not hold on. How do I turn this off and then go like this? Wait, oh, cancel. I don't want to leave the site. Just copy, pasta. Video unavailable. Great, I love that for me. So neat. Is there a way of 3 guys combining to go after her in civil court after the criminal case? That would be so satisfying. It would, but I think it would cost them more money than it's worth. What are they going to get from her? It's the same thing that what's his name, Fred Goldman got from OJ, which was nothing. Yeah, it would cost too much money and they would get nothing in return. On August 21st, Clayton, representing himself, as he did an amazing job, and we stan, filed his answer denying any pregnancy with twins after only oral sex. See also respondents' granted motion for leave to amend response, filed December 12th, and respondents' amended response to petition. Slow down, Bacon. Amended response to petition to establish, filed January 26th of 2024. I'm getting ahead of myself. I'm so excited. If not, you must listen to the new deep dive posted by Seeking Justice on X, a virtual juror or something takes low back. Yes. So I saw that in the Discord. I'm going to have to, I've watched it very loud. I'm too loud? Am I too loud? I'm sorry. Am I screaming? Let's see. On September 28th, though an early resolution conference, parties entered a Rule 69 agreement saying petitioner agrees to contribute a sample on October 2nd to determine paternity of the alleged pregnancy, testing to be conducted by Ravgen. On October 6th of 2023, Laura filed for an ex parte order of protection, claiming that she was pregnant by Clayton and that he was cyberbullying her by posting her medical records online. That same day, the Ravgen results came back indicating little to no fetal DNA, and Clayton thought the nightmare was over. He was very wrong. The virtual juror was top notch. All right, I'll watch the whole thing. I'll watch it. I started it last night and then I fell asleep with my kids. So the method to her madness is to be too poor to be punished. On October 18th, Laura filed a request for pre-decree meditation denied, alleging Clayton would not speak to her, and he even acts as if the unborn... Oh, that he would not speak to her, and he even acts as if the unborn children didn't exist, despite a preponderance of evidence. Ugh. On October 24th, Laura appeared by video before Judge Cynthia. Oh, Cynthia. Jesus died For our Cynthias, wearing what appears to be a fake pregnant stomach, moon belly. Laura's evolving tale regarding May 20th has changed during the litigation, and now she includes a rape insinuation in messages to Clayton in an effort to force a dating contract. Laura acknowledges there was no intercourse and offered that her vagina is tight. After not having sex in more than a year, but then claimed some of his fluids were down there and that I don't know the difference between types of cum. What is my job, you guys? What is my job? It was not until 2024 that she alleged that she was raped after the first alleging that Clayton was too high to remember having intercourse, insinuating she had taken advantage of him. Oh, interesting. That's an interesting point. Gilketsis. Praise Dave. I always think about, I need to watch his thing. She may be a psychopath and not feel normal emotions. An indicator from Clayton's case is her dead-eyed expression in the Deandra DVRO hearing during the verdict, after the crazy faces during cross. Right. What a terrible day to have reading comprehension. That's so funny. She uploaded this image after she allegedly had a miscarriage. Ugh, God. She was also photographed on September 7th competing in a horse jumping competition with a visibly flat stomach and was signed up to compete in late November, but allegedly backed out after attempting to sign up under a different name. On October 25th, Laura appeared before Judge Duty, again wearing what appears to be a moon belly, and testified as to the veracity of a sonogram of their son. It was their son? I thought it was twins. Between spooge types. Which she has since claimed no knowledge of, but that she has sent to both Clayton and the media, as well as including her publicly accessible Dropbox on Reddit. On November 2nd of 2023, the second day of trial on Clayton's granted injunction against harassment, Laura testified that she was 100%. That's not enough, Laura. You're only 100% pregnant. I need 1,000,000%. Yes, please, Queen. And 24 weeks pregnant by Clayton, and that she was due February 14th of 2024. Laura further specifically detailed that she was experiencing a high-risk pregnancy due to her alleged epilepsy, and that she was being seen by specialists Dr. McCool and Dr. Higley, and that she had an appointment with Dr. Higley last Friday. We know this is false. After this court ordered Laura to comply with disclosure, she had refused to comply with Rule 49, not Rule 26. It was confirmed that Laura's testimony was false, and she was never treated by Doctors McCool, Higley, or any obstetrician or gynecologist during her alleged high-risk pregnancy with twins. Laura self-reported to her neurologist, which, listen, I know everybody makes fun of the neurologist. But if you get pregnant by mouth, what other doctor are you supposed to see? Obviously, you go to a head doctor. So I get it. Although that's like ears, nose, and throat. So maybe an ENT. She probably should have seen an ENT. Anyways, Laura self-reported to her neurologist via video while in the seated position that she was 21 weeks pregnant with twins. Laura also told the provider that she saw for the first time on November 14th, 2023, MomDoc, that she had been pregnant and that the pregnancy has been confirmed by Planned Parenthood. So none of these doctors did their own testing. Fair. Actually, a dentist. Right. Also, maybe. I would see my neurologist. I got pregnant in the throat, homie. She passed two sacs that had been told that her blood HCG levels were not consistent with a viable pregnancy. There was no sonogram at Planned Parenthood, and if the latter statement bears any truth, this means Laura was told she was not pregnant before she testified in front of Judge Judy Gielkis, Cynthia, and this court. Good Lord. Where am I at? Oh, page 6. Standing here, packing and giggling like a baby. As with real estate, spooge likewise is all about location, location, location. Did an oral surgeon perform the abortions? Just the surgical ones. Maybe that's why they were never terminated. On December 6th, results of yet another Ravgen test again confirmed little to no fetal DNA. Again, Clayton thought the nightmare was over. He was wrong. Again. Note, the second Ravgen test was allegedly lost in transit. This is why she took the abortion pills early. It's all coming together, you guys. Have a neurologist. Focus the spine. Oh, yeah, I guess, right? On December 12th, Gil Ketsis. All right. Tax packet, leave me alone. Catching my first live. Hi, Lushburn. How are you? Clayton filed a notice of filing affidavit of non-paternity, avowing that he could not be the father to any children from Laura as they never had sexual intercourse. Clayton also filed his granted. I love that this is in just bold, and all of hers are bold denied. I love it. Expedited motion to extend dismissal date on an active calendar and schedule an evidentiary hearing. No logic. More logic. No logic. Haha, Sarah's on my side, Bruce. Suck it. Gail Ketsis. She thought the babies get in your tummy that way. Well, isn't that how they do it? No, I will not. You leave me alone. I will not leave you alone. On December 28th of 2023, Laura filed her denied motion to dismiss petition to establish paternity, legal decision-making, parenting time, and blah, 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 blah. For the first time, Laura's motion cryptically claimed that she is not now pregnant. Did Bacon mute for anybody else? No, that's just you. But after Tony Robbins, you must take suppository. I said this once before, and I say it again. I got pregnant through my belly button. Hey, do you guys want to know something disgusting? So my friend told me that she was like bleeding through her belly button, and I was like, oh my God, what did you do? And she's like, no, your belly button isn't like actually closed. Also, your belly button is your old mouth. Ew. Ew. Gross. Anyways. So yeah, it's not like fully clothed. Or closed. That's how I got pregnant. You just shot it right in there. The same day, Clayton notified of his intent. Sorry, my mother-in-law's in here. I forget you're in here. Thank you, Vanessa. Are you sure about that? She said that, yes, she said that her belly button was bleeding and she went to the doctor and the doctor's like, oh yeah, your belly button isn't like fully closed. Ew. Excuse me while I sew up my belly button. Or what I like to refer to as my old mouth. That's my fun fact. Chat here and while I work. The same day, Clayton notified Laura of his intent to depose her pursuant to Rule 57 as requested. The production of documents pursuant to Rule 62. On January 2nd, Laura filed a denied expedited motion to quash deposition of petitioner. Laura's counsel, her first of 3 attorneys, withdrew. I love it. On January 3rd, Clayton filed a response objection to petitioner's motion to dismiss, as well as a withdrawn motion for sanctions pursuant to Rule 26. Did you guys ever think, you know what, one day I'm going to grow up and listen to some weird girl on the internet read court documents, and it's going to be fun? It's like every day I'm like, what is my life? I love my job so much, and all I do is just read and make fun of court documents. I learn something new every day. Oh, God. Although the court's minute entry dated January 25th, it does suggest that Laura's motion to dismiss was granted but maintained as the issue of sanctions and attorney's fees remain. The court's minute entry dated February 21st of 2024 and discussed in court clarifies that the court was denying petitioner's motion to dismiss petition to establish. For brevity, this background summary excludes all the other response and replies filed in this manner. On January 17th, Clayton filed a notice of non-appearance at deposition pursuant. Oh, we're going to have to remember that I read this when we get to when I get to Clayton's. As a nurse, I've never heard that. What about people with Audis? That's a great. Now I'm. All right, hold on a second. Detour. Hold on. Is your belly button closed? See, this says your belly button is completely closed. When the umbilical cord is cut at birth, the underlying opening where the blood vessels connected to the baby's heart and liver are closed, seals shut, and scars over, leaving the belly button as a dead end indentation. Her doctor told her that it was open. Google says it's closed. Maybe just hers is open. Yes, a belly button can close up, but usually only under specific circumstances. Oh, that's like a completely closed belly button. Oh, God. They told her that it's not completely closed, and that's why she's bleeding through her belly button. I'm going to have to get more details, okay? Listen. Shockingly, no. I thought, let's see. Yes, childhood dreams realized. Oh, I want to see a Netflix series on this so bad. So do I. So do I. Belly buttons are just tied up. Well, they're cut. It's not open from the inside or outside. Your belly button is closed, or else it'd be a route for infection. Maybe hers isn't. She just started cracking out. Oh my God, it has to be. Maybe your friend had a special belly button. That's what I'm starting to think. Your friend needs a new. Was it? Was it mental? I'm gonna call and ask for a specific. Google says it's closed. They open at 10 a.m. They can open it, but doctors can open any part of your body. Wait, no. Now I'm gonna have to ask for details, and I don't want to do that because it grosses me out. I almost gave you guys false information. See, this is why I say do your own research and form your own opinions, because I'm an idiot. Is this better or worse than head cheese? I don't know. I don't know anymore. Oh, God. Okay, back to what we're doing. Clayton filed a notice of non-appearance at deposition, notifying the court that Laura willfully failed to appear at her deposition and requesting attorney's fees. On January 18th, Laura, with her second counsel, filed a denied motion for confidentiality and preliminary protective order, claiming for the first time that Laura had a miscarriage. Notably, no other information about the alleged miscarriage was provided. Interesting. Are you the friend, Bacon? No, I am not bleeding from my belly button. Can't be open, otherwise people would well, shut the fuck. I had a tubal litigation. Wait, I had tubal look at. I'm reading court documents. I had a tubal litigation is how I read that. No, head cheese. And she calls it. I don't know. Listen, enough with the belly buttons. I'm gonna ask her now because I'm very upset. My peoples. Hi, Wendy. On February 2nd, Clayton was deposed by Laura. On February 6th, respondent filed a granted expedited motion to continue trial and motion for additional trial time. On February 12th, the respondent filed a granted expedited motion to set virtual status conference. The court scheduled an in-person status conference. At the conference on February of 21st, the court addressed petitioner's failure to comply with Rule 49. Petitioner claimed that she had a miscarriage sometime in September or October. The court indicated it would hear evidence and testimony as it applies to all pleadings filed within the Maricopa County Superior Court and would be viewing the order of harassment hearings. Pursuant to Rule 59, Clayton intends an offering this deposition against Laura, including discussion of ultrasound. Laura has admitted to altering and presented as an exhibit, as well as the ultrasound videos on pages, all of these. Okay. You started it. Nuh-uh. Nuh-uh. I feel like the belly button can open if you have a hernia or something. I don't know. I'm not a doctor. I'm a collector of gnomes, and the people working on my porch door just broke. Oh, no. I hate that. I do love it here. We love you. Oh, my son smashed my gnome. All I heard, I looked out the window and I had this like big gnome. I had only bought one, and I'm like, maybe I'll be a collector of gnomes. And then I just hear my autistic son outside, and he's like, smash! And I was like, no! And he just everywhere. And I'm like, God damn it. I can't have anything ever. Ugh. I'm going to glue him because I'm the queen of gluing stuff back together. Perfect. On March 1st, Laura was deposed, and it was discovered that there was yet another pregnancy fraud allegation, number 4, from 2014 in San Francisco. Clayton intends to offer the entire deposition as evidence against Laura, consistent with Rule 59. On March 11th, respondent filed a granted motion to compel. And then her attorney withdrew on March 27th. He got a motion for joint hearing and a motion for relief from judgment, which was amended on April 26th. On April 1st, the third attorney filed a denied motion for extension. Extension of time to respond to respondent's motion to compel, and a declaration of David S. Gingras in support of petitioner. Laura Owens' motion for extension and time to respond, blah, 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 blah. On April 3rd, respondent filed a granted motion to withdraw motion. Okay, great. Motion to compel lunch. Request for judicial notice. I am lay tired. Okay, this is motion, minute entries, motion. Mr. Gillespie is expected to testify as he experienced twin pregnancy fraud by Laura after rejecting her and addressed by Judge Backus and Gordon, in which involved a fake sonogram. On April 30th, denied a motion to strike and immediate telephonic scheduling, denied a motion in limine, attempting to preclude testimony from all three men who anticipated to testify that Laura fabricated pregnancies, medical records, cancer, oophorectomies to force unrequited relationships. I have the one that is flipping the bird. I love that. He's my favorite gnome. I don't know where he went. My tragic flaw is anytime someone says, do you want to hear something really gross? I say yes. Ew, I don't. I don't need to hear anything gross. Virtual juror! We were just talking about you. Sorry, I'm yelling. Everybody, round of applause for Virtual Juror in their new in-depth video. We stan a competent content creator. I have to watch the whole thing. I haven't watched it yet. Also, people are telling us that we should, what's the word? Collab. I agree. Motion. I need a gavel sound. Motion granted. On May 10th, petitioner was denied a motion for judgment on the pleadings. On May 21st, respondent filed a stipulated motion for virtual appearance of witness. Non-paternity. This court should find that Clayton was not responsible for any alleged pregnancy. Laura will claim she believes she was pregnant from oral sex. It is farcical and not the legal standard. Even if that was the standard, it is indisputable that Laura did not have any basis to believe that she was pregnant with twins, as she alleged in her petition, because she faked the sonogram records. She never sought obstetric gynecological care. She has never had an ultrasound, and she lied to the court about her high-risk pregnancy with twins. So, there's that. Let's do it. I like it. Email me my email, or you could message me on Instagram or Twitter too. And my email is that's my opinion podcast12@gmail.com. It's in my about. So we'll figure something out. The Laura purchased the watermarked Fiverr. So this is for the sonogram. Laura testified to having a high-risk pregnancy with boy and girl twins, being 100% pregnant and 24 weeks pregnant, being seen by the Higleys and McCools. A screenshot of her making an appointment with Dr. McCool. Okay, it's not the same as being seen. And has testified that she never received care from any pregnancy provider or specialist. Pregnancy is caused by sex. What? What? You're lying. It's caused by sex, not relationship cons. Laura and Clayton did not have penile vaginal sex. Laura's allegations about what happened that night have morphed over time in order to fit Laura's narrative as she is confronted with science and significant holes in her story. I love me some Elton John. What? Where did we go? Where are we going? Let's see. Video after the stream. Yes. Some doctors graduated the bottom half of their class. Hello. I was behind and I heard you say you wanted to see Laura's rash from the case with Greg. I just sent you pics on Discord. Well, let's see. Let's see. Maybe she had a gnome in her belly. She had 2 gnomes in her belly. That's what she said. James. Oh my God, I love this so much. So cute. Okay. This looks like acne. Oh no. Okay. Well, that just looks like a pimple. Here. This looks like a pimple. Belly button cheese. Gross. And then here's this one. Okay. That one looks a little bit more whatever. This would not say rash to me. I'll email you later. Perfect. I love it. Honestly, to me, and I'm not a doctor, this looks like just pimples. Okay, anyways. Those are totes. It's an ingrown neck hair. It's just, yeah, it doesn't look like a rash. You guys want to see when I had MRSA on my face? I have pictures of that. Anyways. Laura's claimed that there were fluids down there and then claimed Clayton was too high to remember, even though she emailed him. Remember, she emailed him. She's like, I don't think you were that high. For my own self-esteem, I don't think you were that high. Ugh. Foggy in this stream is wonderfully disorienting right now. Oh my God. Flea bites. Could just be moles. Well, and the thing is, too, it could be like mosquito bites. It could be whatever. That doesn't look like a rash to me. He was too high to remember intercourse and then claimed Clayton raped her. Laura even sent an email admitting that they did not have sex, essentially begging Clayton to have sex with her for the first time because she was tight and had not had sex in years. Laura's only proof of pregnancy is one urine HCG test conducted at Banner on June 1st of 2023, one blood HCG test on October 16th that indicated levels of HGZ that, by Laura's own admission, are inconsistent with pregnancy. She could, no, Trash Panda. Actually, she can't see a doctor. She can't. So there's that. Rash my ash. Probably from bed bugs in the mesita. Oh, gross. That's her parasitic twin. I have a worse rash from something biting, stinging me while I did lawn work. Mind horse barns. I've got calamine lotion on it. Tight. Maybe she saw a fake doctor that Laura faked on virtual visit, and they told her about her fake belly button. Thank you, Lush Burn. I appreciate that. Shh. Shh. Says Uncle Joe Cotchin. Note, even her October HCG test provided to her expert is dubious, and Laura, through counsel, has admitted to sending an altered version with 102,000 to the media, i.e., Dave. All hail Dave. Laura again fabricated a medical record while simultaneously refusing to cooperate with Rule 49 disclosure. Curiously, in her underlying petition to establish, Laura stated that there was no domestic violence and requested joint legal decision-making and a holiday schedule, as the sexual assault allegation did not arise until after Laura realized Clayton, like others, had zero interest in a relationship and that he was questioning her twin pregnancy narrative. Right. No, she sees the doctor. However, the doctor never sees her. She's too stressed out from suing people is why she can't go to the doctor. She has a, I don't know. Yeah, I don't know about her skin. You are allowed to leave your logic right there at the door before you enter. Any conversation that starts with want to hear something gross is bound to turn out this way. My theory is the twins have been in her belly since the first intimate encounter, and she claims each man dates her as the father. They just live there now. That's their Masita. We need the trial to happen. I want to see what they found. I know. I want to see what they found in her stuff so bad. Note, with Gillespie, Laura also claimed that she had not had sex in years. She later, with Gillespie, concocted a disturbing story that Gillespie and his counsel, undersigned, were involved in her kidnapping and rape, and that it was being investigated by the FBI in an ex parte letter to Judge Backus, which was not true.
Oop. Well, I didn't mean to do that.
I meant to do this. Go to trial, go to trial, go to trial, Laura Owens. We believe you. The twins were real. You were pregnant. Who cares about doctors? Not us. We don't need them. Go to trial. The jury will believe you. If you go to trial, you will win. Just tell your mama and your papa and your auntie. I don't know who else. You don't have any friends? Get your sister. Go to trial immediately. This is literally my favorite song. Toadette, thank you for Curious Minds. We appreciate it. I love that you guys love that song so much. I don't have set words. I just make it up every time. It's great. I love it. I have irrational fear of belly buttons now. Give us context. Do it. Exactly. HCG tests are not dispositive of pregnancy, as Dr. Deans will confirm. HCG can be present in an individual for reasons unrelated to pregnancy, including medications for epilepsy and fertility treatment, as well as if the person injects themselves with HCG. It don't sound crazy. I need to write down what you guys put in there because it's so funny. Yeah, I love you. And this little guy, he shows up. I love that you guys love that song. I forget what the words are every time. It's just go to trial and then whatever comes to my brain. Laura also alleges that she lost 30 pounds and that was somehow proof of pregnancy, or that her body absorbed 24. You know what, Laura? Fuck you, okay? Because how big was I with my kids? I was like 165, 170, and I'm coming down from 150, and I'm 5'4". So guess I'm still pregnant, friends. That her body absorbed 24 to 28-week fetuses, all while competing in horse jumping shows and competitions. Per her records on June 1st, Laura weighed 121.25 pounds. On November, she weighed 133. Me too. I think that should be your intro song. That was a mighty burrito. Oh, I should just open the stream like that. I like that the words change. Okay, let's just keep doing it. Yeah, I'm going to have to start making other stuff up. Once we finish this case, what are we going to do? I'm just going to have to keep it. Obligations resulting in the order to compel. Laura is guilty of both copious perjury and evidence tampering, warranting this court endorsing the Maricopa County Attorney's Office. Yes. Google said the odds of absorbing twins is exceedingly rare. Yeah, especially late. It happens and it only happens in the first trimester. So your girl was 120 and ended up being 199 while pregnant. I don't want to hear it, Lo. We're all still pregnant? Guys, look at us. Look at us. What's a stone? What's a stone, baby? That sounds sad. When my thyroid went wacky. Ugh. Alleged sonograms. Laura faked the sonograms, at least 3 with Clayton. There are no verifiable and requisite sonograms to support Laura's claims of being pregnant with a boy and girl twins after oral sex. On 10/25/23, Laura testified before Judge Duty to getting a sonogram of their son and providing it to Clayton because she was concerned about the baby's profile. I wonder what Sarah thinks about this. This case is never going to end. There will be fodder for a long time. Oh, and that's what we do now. That's what we do. I'm never going to get out of this hole. I've buried myself too far. What do the med pros say about jumping after you found out that you're pregnant? Not to. What? What do you mean you're not supposed to get on a horse and jump while you're in a high-risk pregnancy? Virtual juror, that sounds ridiculous. Now I think you're just making stuff up. Where's El Jacata said you straight on belly buttons? They are closed. I used to say that. And just like a belly button, I'm outie. Right. His fluids. She talks like a 14-year-old. Whom she accused of using it to make an online Halloween meme, which he vehemently denies. Laura also admitted an exhibit where she tells Clayton that she has a sonogram video. Laura used the doctored sonogram as an exhibit during her deposition of Clayton. Laura testified to obtaining the same sonogram anonymously at Planned Parenthood in Mission Viejo on July 7th and falsely and illegally attributing it to Southwest Medical Imaging, and that she found out she was pregnant with twins in July on or about 4/15. I should not have read this, because this should be in Clayton's thing. I guess I'll just have to read it again. Nurse rabbit holes. It's good for babies. You're going to have a new brother-in-law or sister-in-law. I'll let you know which when I find a sonogram. Let me smell it. I love a new baby. I want to have a new baby just so I can smell it and then give it back. I love the little baby smells. Pizza for a month. Cyst is a small pouch or channel left over from fetal development that never fully closed. It becomes inflamed or infected. Oh, that's crazy. It's completely, totally safe to do whatever you want with your fetus on horses. Sorry, you caught me. Laura, is this you? Is this you, Laura? High-risk pregnancy. My doctors, I had a high-risk pregnancy, and at the end of my pregnancy, they told me, I mean, I guess I could have done whatever I want if I was a shittier person, but they told me at the end of my pregnancy, within like the last 3 weeks, are like, you cannot travel farther than 10 miles from the hospital. Like, you need to be here, and you need to be able to get here immediately. Belly buttons are closed, but babies are born without kneecap. Dude, shut the fuck up. I'm so grossed out right now. Oh, God, I hate it. Stop it. Your Honor, I only gave it to Clayton and the Reddit people. That's why only he can have posted that. Let's see. What do we got? The only sonogram Laura states, gestational weeks, 6 weeks, 4 days. Okay, we know she doesn't have any of this. Sexes would not be discernible until about 16 weeks. Laura texted Clayton, we are having a boy and a girl, and I have an ultrasound to show you that, and dated it literally exactly from when we were together. Laura's Exhibit 6, an email from Laura to Clayton, admitted during the order of protection. Planned Parenthood confirmed they do not offer anonymous appointments. Hi, Kris Jenner. The weight number doesn't mean anything. I'm 5'2". If weighing in 120s or teens, bones stick out. I don't think healthy, but build matters. Yeah, build matters for sure. Babies are born with 270 to 300 bones, and adults have 206. Oh, right, because they have to grow together, and they get the growth plates. I have a funny story I'll tell you at the end of this stream about that. Remind me about the growth plates. Consistent with ultrasound images generated by their practice, still Laura signed an affidavit for her expert that included the fake sonogram that stated this image was taken at Planned Parenthood, emphasis in original. No evidence supports Laura ever being seen by any provider for an ultrasound. At this court noted, neither Planned Parenthood in Mission Viejo nor Smile have any records for any ultrasound. Ew, yeah, babies have fingernails. Then they fuse together, that's right. They also have a full set of teeth, or 2 sets of teeth. They have 2 full sets of teeth. Yuck. Anyways, Laura was never pregnant by Clayton and could not have miscarried Clayton's twins. Laura's miscarriage tale, now apparently dated July 23rd, only arose after she was confronted by Clayton's desire to prevent her from getting away with her extreme pregnancy fraud con and exploiting another TED Talk or chicken soup essay. This included Clayton notifying Laura he had contacted for the putative father registry to prevent Laura from claiming she put the twins up for a pretend adoption as means of explaining their non-existence, all after testifying she was 24 weeks, actively being seen for high-risk pregnancy and due in February. Meanwhile, Laura continued to post on Reddit, published various blogs on Medium.com, portraying herself as a victim and contacting the media to advance her fictitious narrative. You're supposed to keep your records, but why? Exactly. Who knows? Who knows? You guys don't just get them and, like, light them on fire? That's what I do. The last story you told us was about open belly buttons and somehow led back to head cheese. I'm not to blame for what comes out of my ADHD face, okay? I'm 4'10" and gained 10 pounds when I was pregnant, gained 10 pounds more after my kiddo was born. Weight is not an indicator of pregnancy. What? It's not. This is not the first time Laura has feigned a miscarriage or leveraged offers to terminate a pregnancy in exchange for the victim agreeing to date her. With Michael Maricini in 2016, Laura alleged that she was pregnant with his twins that she believed had a miscarriage and that after speaking with providers, she knew what to look for to determine whether she was miscarrying. Clayton disclosed 2,500 pages of text messages between Michael Maricini and Laura in light of Laura's repeated claims that her victims, including Michael, have fabricated or tampered with communications. A computer forensic expert assessed the metadata and confirmed that there was no tampering. And this confirmed that Laura historically claimed she had. And it ends there. Okay. Baby girls are born with all their eggs. I did know that. Hi, late to stream, listening before my teen gets home from school. Good. Don't let them listen to the stream. We are not for children. Like she would sue Greg for abortion coercion, but then mysteriously give up precious twins for adoption with Clayton. Exactly. There was a deposition with victim number 1. Was there? Well, he did get an attorney, right? He did get an attorney. I weigh now more than I did at my heaviest during my 4 pregnancies, 3 living kids, 1 miscarriage. I'm so sorry, Susan. I'm definitely not pregnant right now. Oh, boy. Or does he just mean her deposition with this case? I think just the deposition with this case. With Gillespie, it was offering to abort the twins if he agreed to date her. With Clayton, Laura alleged for the first time that she miscarried when she requested a protective order. Laura self-reported to MomDoc, a provider that she had never seen before, that she passed 2 sacs, which appeared to have a membrane, but denies having much bleeding. Okay. Victim 0, as I called him, was found because there were court docs from that case. Got it. I lost weight with my pregnancies in the 1st and 2nd, and then gained in the 3rd. Yeah, it's different for everybody. It's sealed. That guy doesn't want to come forward in California. Good. I wouldn't either. Leave that man alone. During the status conference, Laura told this court that she miscarried sometime in September or October. Days later, at her deposition on 3/1/24, Laura testified in her September-October she passed 2 sacs that were less than the size of her hand. She took that picture of them and then sent it to an online provider. Imagine okay, let me just explain this. You have what you think is a miscarriage. Obviously, we know this is not real, but listen to how absurd this sounds. You are holding in your hand what you think to be two children, two living children, and you snap a picture and send it to an online provider, and then what? And then what? What do you do with them? Where do they go? You're not concerned, Miss, I want to be a mother so bad? You're not concerned about these children that you're holding in your hand and you're taking fucking Instagram photos of, whatever the fuck you're doing? What? Yeah, there's a lot of blood. She claimed to be 20 weeks at this point. Just going to let you sit in that pot for a minute. Speaking of pot, I have to go to the bathroom. Enjoy yourselves for 3 seconds. Okay, everyone. Hello, I am back. I also didn't go digging. She doesn't want the babies. She wants the leverage. I didn't find them. I know about them because of the info from Yes. I'm glad they're sealed. Better off for him if they are. That's true. My entire miscarriage experience was traumatizing. For my husband and me. It took us about 6 years and us not to get choked up discussing the loss. The baby is still considered a member of our family. Of course. Of course. Let's see. So you don't have the docs yourself. I don't remember hearing that she claimed to be 20 weeks pregnant. 20 weeks pregnant. For which one are we talking about? Because this is 24. Laura via counsel stated that she passed 2 sacks before Laura filed underlying petition, before she testified 3 different judges about her feigned pregnancy. Clayton's experts have reviewed the images, which may be fake, but even assuming they are real, Dr. Deans will testify that there is no obvious embryonic fetal tissue, which is complicated by the theory that Laura would have been miscarrying twins that were 8 to 11 weeks and would have experienced significant bleeding. Laura refused to provide her phone to a forensic expert to confirm the image's authenticity, which is highly dubious given her admitted history of fabricating records. Oh, and this footnote. Okay. Claimed she had ovarian cancer and an ovary removed, in addition to alleging she was pregnant with twins, had a miscarriage, and severe allergic reaction to an abortion drug, even though she had taken it multiple times while talking to Michael Maricini. But there's that. And that only one of the fetuses was terminated via abortion, which she also told Gillespie. Yeah, there's no maternal feelings here. With Clayton, during one of the testimonies she gave on Zoom WebEx, whatever she claimed to be 24 weeks, then later came back, say she's miscarried, saying it passed like sacks. Right. Kind of looks like hives. Not only am I still pregnant based on my weight, but I've got an entire foster family in here. Ovarian cancer 5-year survival rate is 50%. Interesting. I bet they found them in the raid. I want to know what they found in that raid so bad. So bad. So bad. Yes, that was Clayton's case. I thought you were saying she claimed to be 20 weeks with... Oh, right. The argument that he was too high to remember is an admission to having sex with someone when they were able... Right, and that's what he says in here. Is he says the fact that she's saying that she took advantage of him. Laura also was engaging in repeated communication with Clayton and the media, referring to sonograms in the videos that showed she was still pregnant, in addition to testifying before 2 judges in late October and early November, being 100% and 24 weeks pregnant. There is no record indicating Laura showed any provider these 2 alleged 2 sacks. And also, she showed up with the moon bump. We know she was on with Deandra, and she's like, I am 100% pregnant. And no, you weren't. And you would know that. Ugh. This would be amazing. This would make my whole life. The OOP against Eckerd must be dismissed because it was procured through intrinsic and extrinsic fraud by Laura. Clayton's positions are well summarized, ruling and fully briefed in the motion for relief. The order was upheld by Judge Duty, who did not know the history of fraud, nor did he seem to care in what I've seen, but I haven't watched it as a whole, as a result of intrinsic and extrinsic fraud by Laura because she was never pregnant with his twins, and the ultrasound in the image Judge Duty found to uphold the order of protection was manufactured by Laura, who has since denied the image belongs to her, despite sending it to Clayton and the media and including it in her public Dropbox on Reddit. Dear friend died of ovarian cancer, diagnosis at stage 0, still passed away. Oh, Dana, I'm so sorry. Imagine being so compulsively dialed in that you find every single little thing about you on Reddit that points to the point where you call the cops about a meme about you, and yet when you pass 2 sacks, nothing. Exactly. I was fortunate enough to never have a miscarriage, but I drove a friend to the doctor and sat with her when she had one. They did an exam to be sure she passed everything so she wouldn't get an infection. Exactly. Exactly. Because that's what happens when you go to doctors. If you're taking abortion pills, how do they only abort 1 fetus and not both of them? It makes no sense. Trish, there will be no logic here. None. None. You can't. You can't. Don't hurt yourself. Don't hurt yourself. Medell, hi! I've never been pregnant, but aren't you either just pregnant or not pregnant? What does 100% pregnant mean? Can you be 75% pregnant? I don't know. A miscarriage can be life-threatening, but doctors are not important. They are not. They are not. Who needs one? Why do you need to see one? Why? Why? The way she sexually harassed him really isn't acknowledged widely enough. Right. Right. She bought the weird long sleeve, stretchy beige maternity shirt, and I'm guessing Moon Bump was bought at the same time. Yes. 75% cooked. My friend's doc sent her home with medication instructions on how to care for her and follow-up visit. Wouldn't not 100% pregnant mean retained tissue or molar pregnancy or not viable pregnancy? I don't know. Wanted to say hi. Is it Steven? Stefan? What is it? I want to call you by the right name. I heard logic from the kitchen. What the hell? What the hell? Maybe her allergic reaction was because she took suppository pills by the mouth. I don't know. She doesn't know where to put what, obviously. This court has broad authority to assess the conduct of Owens throughout the 3 proceedings before 3 different judges and sanctions Laura pursuant to ARS. Okay, Laura ignored disclosure obligations, right, because why disclose anything when you have no evidence? Nearly 7 months, and it was not until the court compelled her cooperation that evidence of a fourth victim was revealed or that she committed to her recent tale of miscarriage in July. But despite allegedly passing 2 fetuses less than the size of her hand, she allegedly did not know she had miscarried until November and curiously did not inform Clayton or this court until January. Stephanie. Perfect. So I got it wrong both times. Steph. Oh, God. I love it. Steven? Stefan. Just wrong all the way around. I love that for me. That's great. That's awesome. Her allergic reaction was BS. If she had a reaction with Mike, but also she took pills with Mike and then she took them again. And then she's like, I had an allergic reaction. It's like, but you already took them. What's that? Disclosure? Right. She has no idea because there's no evidence. Laura's conduct cannot be accurately captured in the word unreasonable, as faking a twin pregnancy after oral sex, doctoring and submitting medical records, threatening witnesses, and committing continuous perjury deserves a word more benefiting behavior beyond even the family court pale. In addition to fraud underpinning the entire litigation, the court merely needs to read Laura's Medium articles, the tweets, and blog posts to appreciate the scope of the damage she has caused, which is as recent as May 28th, includes a joint blog post from Laura and her counsel and YouTube postings of Clayton's video deposition. After reading that, I need a cigarette. Zaddy is on fire. Zaddy is on fire. Steven! I thought you were dead. I had a miscarriage when I was 18. A miscarriage hurt worse than actually giving birth. I thought I was dying. I had to have a DNC a week later to remove everything so I wouldn't go septic. Thank you for sharing your story. And that's why, like, everybody was talking about this in the chat. Child loss is not something that I've ever dealt with. I've been very lucky. But, you know, for everybody who shares their stories in this chat, that's why we continue to do this. That's why we continue to talk about this, because she continues to just so frivolously use people's stories who have gone through this real trauma, who have had these real experiences. And it just, it's so fucking aggravating. Zaddy is fire. Oh, snap. Where's my Kindle remote? 10 to type, Steph. I'm talking instead of typing. Oh, no. It's just funny that it's Steph, and I'm sitting here, and I'm like, Stephen? Stefan. Steven? I don't know. I'm an idiot. Clayton is entitled to all reasonable fees and costs incurred pursuant. To date, Laura has provided no evidence to support that she was ever pregnant by Clayton and with Clayton's twins. Laura has refused every opportunity to resolve the matter outside of court and all efforts to comply with disclosure, including failing to appear at a scheduled deposition and not fully complying with the eventual order to compel. Recall, this entire saga was initiated by Laura going to the Sun and making false claims of pregnancy, ostensibly because Clayton rejected her. Laura's order of protection and the underlying petition were both filed in bad faith, as Laura knew that she was not and could not have been pregnant with Clayton's twins. Then Laura proceeded to fabricate evidence that, for the first time, testify before 3 judges to being 100% and 24 weeks pregnant with twins. I love that he keeps bringing up the 100%. That makes me so happy. And filed irrational and legally unsupported filings that continue to assert what Laura cannot prove, that she was pregnant with Clayton's twins. And it was more than just simple misstatements, as this extrinsic and intrinsic fraud upon the court, encompassing false testimony, altering evidence, and using coercive threats to tamper with potential witnesses and extort Clayton. So, no, that's okay. We're happy to have you. I don't care. It's great. I speak to text all the time, and then it messes up when I'm watching people's live streams. Laura, the day before her deposition on March 1st, sent Clayton a letter threatening to sue him for collateral allegation for around $1.4 million unless he agreed to dismiss this action. This overt extortive effort is eerily similar to Laura's antics with Judge Backus in the Gillespie matter, where she maliciously claimed Gillespie and his counsel were involved in her rape in an attempt to avoid a hearing. I had 8 pregnancies and have 2 miracle kids. I'm a miscarriage expert. Scranton, I am so sorry. I feel like low with my nonsense comment, right? It's Steph. Just because Mr. Bear's double. That's so funny. As a witness, Maricini and Gillespie are expected to testify. Laura fabricated medical records, including sonograms, in her pregnancy con with their fake twins. At the same time as her claimed high-risk pregnancy, Laura was actively participating in horse jumping competitions with a visibly flat stomach, contrary to her very visible moon belly. Through her third counsel in this matter, Laura has intimidated witnesses, including suggesting Maricini should be arrested if he appears to testify, filed legally unsound filings designed to waste fees and delay trial, sent over threats and harassing communications to Clayton's counsel and members of the media, engaged in toxic and inappropriate diatribe regarding this case through Twitter and blog postings, including using derogatory terms, insinuating that any ruling in Clayton's favor would be a mistake, and that the judge was biased against Laura and appeared to intimidate Laura's own prior counsel into refraining from complying with his Rule 3.3 ethical obligations, which is the Rule 3.3 notice of candor, where her lawyer came back and was like, hey, when I was representing my client, I didn't think I was lying. Now I'm unsure. But this is a you problem now, is basically what he said. No way an expelled miscarriage past 4 or 5 weeks goes unnoticed. Exactly. Why have a 1099 or W-2 when you can sue? Exactly. Exactly. Do y'all ever think Lo ever joined? Absolutely. Absolutely. I think she gets so mad. So mad. Clayton will testify to all issues. Laura will testify to all issues. Michael Maricini, former romantic partner of Laura, is expected to testify regarding the origin of the 2,500 pages of messages with Laura from 2016 to 2017, where she made nearly identical claims involving fake twins, miscarriages, abortions, threatened suicidality, including claiming to be admitted into a mental hospital. He is expected to also testify regarding the personal claims in Laura's recent affidavit claiming he faked her medical records, which have been disproven by forensic technology expert who verified that the medical records indicating ovarian cancer ovary removal were sent to him by Laura. Sorry, I hear my children. Anyways. I also watched a terrifying movie about a woman who faked a pregnancy to keep her boyfriend and then stole someone's baby 9 months later. It's next level. That's a good point. She would be all over the chat. That's a good point. Gregory Gillespie, the former romantic partner, that's a stretch, of Laura, is expected to testify that Laura fabricated being pregnant with twins, claimed she had an abortion several times, and repeatedly stated that she would dismiss her lawsuit if he agreed to date her. Gillespie is expected to confirm that the sonogram of twins sent to him by Laura is from Fiverr. He is also expected to testify in response to Laura's allegation that he doctored her medical records. Greg, master hacker. I hear my kids. That's why I was like, making slow-mo. Dr. Samantha Deans will testify regarding her expert review of medical records of Miss Owens, including her analysis that she alleged HCG tests were never dispositive of pregnancy and that the related miscarriage timeline, which includes details of analysis of the likely origin of the HCG in petitioner's blood and urine, is not indicative of human gestational norms. Her testimony will also address the veracity of the petitioner's miscarriage of 2 fetal sacs and alleged sonogram from Planned Parenthood. John Barry Hill, a forensic data expert, will testify regarding his expert review of personal computer of Michael Maricini, including his analysis of the metadata, which confirms that no text or images sent by either party were altered or otherwise fabricated. Hey, Samantha, thank you. Thank you for joining. Enjoy your member perks. I randomly hear my children in my house when they're at school, or yeah, I have that all the time. That's why when her lawyers say she had a miscarriage but doesn't know when, BS, you do not miscarry and not know. I'm 44, and it was yesterday. I have 3 healthy, beautiful kids now. Yeah, I don't understand how a lawyer could be like, oh, she doesn't know. She doesn't know. She definitely listens. She was either going to claim miscarriage or find a baby. She's all in the chats. Let's see. Bye, Nikki. Respondent's objections to petitioner's witness. Respondent objects to any and all of petitioner's witnesses and have not been timely disclosed. Respondent specifically objects to the expert testimony of Dr. Medchill under Rule 702, as he relied on an admittedly tampered with data set made inappropriate conclusions regarding his beliefs unrelated to science, and appears to have concluded with zero scientific DNA basis that Clayton was the father of twins. His testimony is not the product of reliable principles and methods or based on sufficient facts or data, and his opinion does not reflect a reliable application of the principles and methods to the facts of the case and should be precluded or given the weight it deserves. And then this is all the exhibits that they had put in that we've watched this hearing, so we know. Respondent objections to petitioner exhibits. Petitioner submitted admittedly falsified medical records to her expert to review, including the sonogram that she admitted to tampering and which has been confirmed not to have originated at Planned Parenthood or Smile, and notably not including the ovary removal she allegedly had in 2016, which she appears to be claiming she does not remember fabricating. Of course she doesn't remember it, because she's fabricated so many of them. Her expert relied on fabricated data to reach his conclusion. Yeah, that's interesting. Why, bye Stevie, why would the doctor allow... why would the judge allow this to come in if he was not able to make a proper claim because he didn't have the proper documents? Huh. Her expert relied on fabricated data to reach his own conclusion, which in itself is inadmissible under 702, meaning his written opinion is not based on those kind of facts or data that experts in his field would reasonably rely on. I wish I could sit in the casita all day surrounded by piles of clothes instead of going to a job. Respondent objects to any and all petitioner's exhibits which have not been timely disclosed. Respondent objects to any and all petitioner's exhibits which have been doctored in any way, including to those already admitted to being fabricated by petitioner, which were confirmed not to have originated from any source. Petitioner testified being seen by. Respondent further objects to any petitioner's exhibits which are not relevant, cumulative, or lack foundation to those proceedings. Respondent is unable to prepare specific objections as petitioner has not disclosed her list of exhibits. And that's that on that. Woo! We did it! We did it, friends! Why didn't the expert get releases and get direct medical records? Right. Exactly. So haven't gotten there yet since I'm going chronologically. Claimed. Yeah, so on my channel when I did my videos, I did like a skim surface to tell the story, and now with the live streams we're doing like deep dive. It's how It's wild how she apparently did zero research on pregnancy, abortion, or miscarriages. She has the knowledge of the average U.S. teen, not a woman in her late 30s. The doctor testified he excluded the sonogram from consideration, but didn't apply any logical question of accuracy to the information he was provided. Right. Claimed oophorectomy 8/20, 2016. Show jumping November 26. Fused abdominal surgery. Right. Okay, so what's next? So we have this. May 10th, Greg Gillespie emails David Gingras stating, checking in, just wanted to make sure you're okay since you never replied back. I don't want to have to call for a wellness check. Gingras responds, frustrated, Greg will not speak to him before the trial. If you seriously care about justice, you'll talk to me. We already read this. Yeah, we already went through these emails. We just did that in this stream. So there's that. June 10th, here's the hearing. We'll go through that later with Clayton. We don't need to hear that right now. Here is a police report that we could read. It's 1 page long. Here we go. Laura calls Scottsdale police report to Greg. Hello, shoe store. Let's see. What do I want? Laura calls Scottsdale police to report Greg, Clayton, and Michael for restraining order violations. Ring, ring. Scottsdale police, this is Riley.
Hi, I'm calling to report violations of multiple restraining orders.
Okay, what's the address where this took place at?
It actually took place online, in one of them.
Okay. Do you have a Scottsdale address?
Yeah, I do. And one of them was actually at the Northeast Courthouse. So do you want that address or do you want mine?
We'll just go with yours and then we'll log the information. What's your address? And what is your name?
Laura Owens?
And what's a good telephone number for you? Okay. And how long ago did this take place?
Yesterday and the day before yesterday.
And who was it that you have an order against?
So I have the order against I have an order against 2 men in Arizona and 1 in California. And they were all together and kind of coordinated. It's kind of complicated. Do you want the men's names?
Yeah. If I could get them.
Yeah, absolutely. So it's the first one is Greg Gillespie, Gregory Gillespie.
How do you spell the last name?
Gillespie. I have it tattooed. Just kidding.
Do you have his date of birth by chance?
Let me see. I have the order, so I'm guessing that it has it on it.
All right. And the second subject?
Clayton, and the last name is Echard.
Do you have that date of birth? And they are order of protections that you have against them?
Yes. I have orders of protections against those 2.
Okay. All right, Laura. What I'm going to do is have an officer give you a call to talk to you.
Oh, and there's one more.
Oh, there's one more?
There's one more. I'm sorry about that. The other one is actually Yeah, it's a California order. I got the order in California and then moved to Arizona, but I was told by San Francisco police to contact you guys.
Mm-hmm.
So that man's name is Michael, and then I can spell the last name. It's Marraccini.
And what is Michael's date of birth? Okay. Okay. What I'm going to do is have an officer, like I said, give you a call to talk to you about making a report. It may show up as blocked or a restricted number when they call you. So just for the time being, make sure you answer any phone calls you receive until you hear from us, okay?
Okay, sounds good. Thank you so much.
You're welcome. Have a good rest of your day.
Okay, you too. Bye.
God. Oh, God. Back to the beginning here. She doesn't even sound like she's ever actually seen a person in OBGYN in person. But did doctor in court know sonogram was fake, or did he, or just didn't consider it? I think he knew it was fake. I don't know at the time. I don't know. I was worried for the pregnant women in Scottsdale. Yeah, a lot of people have made that claim. Her expert claimed he didn't use the tampered data, only the HCG drawn by labs, but those were provided by Laura, not the labs directly. And one of them says that was one of the ways Woodnick impeached his testimony. Such a load of shit. She sounds much more chipper than that when she's making these calls. Oh, sorry, I have to be much happier. It all starts to blend together because it's so repeated. Right. The demon voice, but you have to do it like it's ordering Chinese food. It took place at a court where 900 cops were there for security. More upbeat. That's right. All the men. How do you know she said Laura Owens with the question at the end? She said it. She 100% said it like Laura Owens. That's just how she says her name. Like when anybody asks her, what's your name? Laura Owens. Any man that crosses my path and rejects me. And which one of your 13 phone numbers can we reach you at? Yeah. I thought she actually got a tattoo. No. Why wouldn't they want the names of the men who she's accusing of violating restraining orders? Exactly. Embarrassing. Oh, God. Levels of pregnancy, 50%, 75%, 100%. How many people have 1, let alone 3 restraining orders, let alone court cases? Laura purchased HCG. I don't think she has tattoos. I think she has secret names for her horses when she's brushing them. And that's a good boy, Clayton. That's a good boy. That's so funny. Oh, my God. Let's see. There's a police report. Here's more oh my God, are we going to finish? Did I just do that to myself? Hold on. Are we going to finish Gillespie today? Shut up. Shut your mouth. This would be so amazing. I made it home. I'm also traumatized by the open belly button story. Funny and slightly terrifying. It's like Lo is unsure which identity she's currently speaking under, so a question every time she says her own name. She doesn't know who she is anymore. She tries to act. I truly think she just tries to be somebody else. Let's see. Hold on. We could do this. Let's see. Greg sends email thanking him for the entertainment. Okay, so we have this, which we haven't seen. So this is from Greg to, I don't know how to make this bigger. All right. I don't know how to make this bigger, but this is from Greg. Judge Matta, oh wait, like this, because I'm dumb. Judge Matta and the district attorney are the voice for the real victims, me. Anything I need to say, you can hear loud and clear through them. The JFC crew is just a welcome side dish to the main course, and they support the truth, something you find hard to believe. That is the only questionable behavior here. My voice, the truth, is court-ordered. So that's a non-negotiable, and about the only way I choose to communicate important information regarding my involvement with your client. I want justice for the injustice that nearly derailed my life. And thanks in part to your poor performance across the board and Laura continued criminal arts and crafts, we are getting closer to justice. You call being a victim being an obsessive stalker rich. My voice and karma are being heard loud and clear since the adult legal playground in which you call your profession failed me miserably. You hold a bigger stick in that arena, and therefore I know better than to provide you with content you can stew up in your cauldron of lies. Take care. I just wanted to say thanks for sinking the ship, Captain. P.S. Don't call me again. I won't block your number. Just honor the request. Huh. Files another order of protection, and I don't know if she gets this. I realized sewing it closed was dramatic, so I'm going with super glue. Speaking of horses and men, one of the blurbs intros into the family farm business website talked about horses like she talked about men. Being an unbeatable team, feeling powerful together. Ew. Girl, you're killing it today. I have been to 3 different Targets just since you've been streaming. Thanks for keeping me. Why? What does the first Target not have that you have to go to 3 different Targets? What do they need for you? But thank you. Okay, so this is a petition and order of protection. This order shall be enforced. Finding no crimes, blah, 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 firearms, yada, yada. If you disagree with this order. Okay, great. Here we go. This is what we need. Her lying. On September 28th, Reddit user under the handle, I'm going to say Silly Goose Tits, posted, hey, Parapet, can you crochet me a goose with tits? It's for research purposes. Please. Posted an order of protection against me, one that Greg Gillespie obtained in August of 2021. And just the day after, I filed a civil lawsuit against him for abortion coercion. Where's my little thing here? Oh, okay. This order was never served, meaning it was never legally in effect. According to Manny Vargas, we already read this, blah, blah, blah. Only Greg would have accessed this unserved document. Not even I, the named party, could have obtained it directly. Manning confirmed on a recorded phone call that Greg had not only picked up a paper copy of this order, but also requested to have it emailed to him. This timeline is significant because the post appeared on Reddit the same day that Greg collected the document from the court, demonstrated a clear chain of events. Greg's own admission to the police that he collected the document aligns directly with the Reddit post appearing shortly thereafter, indicating that he was either directly involved or indirectly facilitated this leak. This action, retrieving the document, then either posting it to himself, allowing it to be posted publicly, is not an isolated incident, but part of a broader pattern of harassment where Greg continually seeks ways to harm my reputation and cause me distress by ensuring that the document was posted online. He engaged in conduct that is unquestionably intended to intimidate, embarrass, and harm my standing. This act runs counter to the no crimes and no contact clauses of order, as it is a clear attempt to circumvent direct communication while still causing reputational harm. Furthermore, the nature of this act distributing a document he knew was unserved and therefore invalid suggests an intention to mislead and malign, aligning with pattern of indirect harassment meant to disrupt my life. It's for science, I promise. I promise. Maybe Gemini can do that for you. What? Gemini. Like the AI? I asked AI for a Silly Goose Tits logo, and it was like, I can't do that for you. Hi, LSB. LSB. Also send me the pattern. Also for research purposes. My mother-in-law is a very accomplished crocheter and can crochet just about anything. I have so many crocheted blankets from her here. Right. On October 6th, I obtained an order of protection against Clayton Eckerd. Just weeks later, on November, Eckerd obtained an injunction, an IAH against me during the pre-assurance continuance hearing for this injunction. Mr. Gillespie attended the court session ostensibly to support Clayton, a man he had no prior relationship with until I filed a paternity case against Mr. Eckerd. Gillespie's presence undeniably strategic. He appeared there with no legitimate reason, clearly expecting I would be present, hoping his appearance would shock and unsettle me. He had absolutely no connection to the case and was not a witness or involved party, which makes his attendance purely and simply an attempt to intimidate me. This behavior is a clear violation of this order of protection I hold against him, as it constitutes an intentional act to confront or intimidate me. His actions reflect a blatant disregard for the terms of the order, as he appeared at the place that he anticipated I would be solely to cause distress. I'm reading really fast because I'm trying to get this done before 2:30 so we can be done with this and move on. Whether you guys, let me know, 1 for Michael Maricini and 2 for Clayton Eckerd. Where do you guys want to go next? I don't care. We'll do whatever. Or we could start at the very beginning and go through the other stuff. And just go all the way backwards. I just picked Greg because the trial was coming up. Or so we could do Clayton for the trial, whatever you want. Although I was able to attend virtually due to last-minute decision by the judge on the morning of the hearing, it is evident that Gillespie presumed he would encounter me there. As a part of his ongoing harassment, Gillespie has publicly leaked private emails, text messages. That's so funny. That is so funny. Somebody just sent me a message on Twitter, and it is of Silly Goose Tits, and I love it so much. That's so funny. The unsolicited messages I get on this by doing this now, it makes my day. These private communications have been featured in YouTube videos by content creators such as Dave Neal and Dr. Hines, where they are used to scrutinize and disparage me. Gillespie's decision to release personal conversations publicly is a clear violation of the protective order. The order explicitly prohibits direct or indirect contact and any behavior that could reasonably cause harassment or distress by ensuring that my private interactions are broadcast to a wide audience. Gillespie is clearly using these leaks as a mean to intimidate, embarrass, and provoke emotional harm. This is indirect harassment designed to discredit me and cause ongoing distress, and it clearly disregards the protective order's terms, which were put into place to prevent precisely, can she say this in less words, this kind of intimidation. Gillespie's repeated and public exposure of my private communication reveals a clear intent to harm and manipulate my reputation, turning what should be protected private exchanges into tools for harassment. His actions demonstrate a blatant disregard for the order and safeguarding my privacy and well-being. Oh my God, nobody cares about you this much. This is too many words. Greg Gillespie has made a public statements on his Instagram account under the username whatever. In a particularly alarming post, he wrote, "Stop this woman. No one should cave to her harassment. She is dangerous." This statement publicly labeling me as dangerous, accusing me of harassment, serves no purpose other than to harm my reputation and incite fear and distrust among those who see it. Publicly characterizing me in a way, Gillespie is actively attempting to influence others' perceptions and create a hostile environment for me. Such language calling me dangerous and accusing me of harassment is intended to provoke others to act against me, effectively encouraging third parties to stop me. This kind of inflammatory statement goes beyond personal opinion or commentary. It is calculated effort to portray me as a threat, encouraging others to engage in or support his campaign of harassment. This behavior directly violates the terms of blah, 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 which prohibits indirect contact, any actions that would reasonably cause me distress, harm, or harassment by spreading false and harmful narratives about me on a public platform. Gillespie is engaging in a form of indirect harassment using his social media presence to harm my reputation and provoke fear. This post illustrates a continued pattern of intimidation, as Gillespie is not merely airing grievances but actively attempting to harm my standing in the community and incite further hostility. His actions represent a blatant disregard for the protective order, which is meant to prevent precisely these types of aggressive public displays intended to intimidate and cause harm. God. I need more coffee in my TR&B hole. God. On August 4th, I received an email from somebody informing me that a woman named blah, 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 an associate of content creator Dave Neal, had obtained intel about me directly from Gillespie. According to the email, information was shared with the assistance of a woman named blah of blank, and was specifically intended to harm my reputation through wider dissemination. This demonstrates that Gillespie has actively collaborated with others to share private or harmful information about me with the apparent goal of exacerbating the distress and damage caused by his actions. Gillespie, his actions are not protected by speech under First Amendment, as they serve no legitimate public interest and are expressly intended to cause harm. Contrary to the restrictions of the protective order, the order prohibits not only direct contact, but also indirect actions reasonably expected to cause distress, harassment, or harm by enlisting third parties to disseminate private information with the intent to discredit and intimidate me. Gillespie is actively circumventing the court's restrictions. The calculated effort reflects a clear and ongoing disregard for the boundaries set by the court. The involvement of third parties in these actions exacerbates the harm and creates a wider circle of hostility. This is not lawful expression, but targeted harassment intended to intimidate and cause reputational damage, violating the protective order. Gillespie's behavior is a direct attempt to use others to achieve what he is forbidden to do himself, further demonstrating his intent to undermine the legal protections afforded to me. On February 22nd, Gillespie attended a court hearing related to my paternity case with Clayton Ecker. Gillespie had no legitimate involvement in the case or reason to be present in the courtroom. According to an article published by the Arizona Republic on the same date, Gillespie attended the hearing as an observer and declined an interview afterward. His presence at the sensitive proceeding was clearly intended to intimidate and distress me, knowing that his attendance would cause discomfort and emotional harm. At the time of this hearing, Gillespie was not listed as a witness in any capacity. This designation only occurred later. On March 29th, his attendance on February 22nd had no connection to any legitimate obligation and was solely an act of harassment. This behavior directly violates a protective order which prohibits indirect harassment and any actions reasonably expected to cause me distress. I have 2 orders of protection against Gillespie, one served November 15th that was in effect for 1 year, and one that was served on December 2nd that was in effect for 2 years. God damn it, I did it! I did it! I probably have that weird white shit around my lips. I'm so thirsty. So thirsty. Oh, it's nice. That's nice. Boo! Boo, this woman. Yes, I have rabies. No, you just like know that weird shit that you get when you're like thirsty. Oh, God. She is harmful. Guys, I am so tired. And that's it! We did it! We did it. Do it again. I'll kill everybody. What? No! 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 White stuff around the mouth started this mess. Oh, God. We're done. We're done. I'm spent, guys. I am fucking spent. Oh boy. Anyways, you guys want to see this picture that somebody just sent me? Oh my God. Hallelujah. Dave-alleluia. Also, growth plates. Oh, okay. So you guys want to know about growth plates? Okay, listen, I can tell you this story really quick. So one time my son was in gymnastics and he was 2 years old and I took him to like a mom talk class. And anyway, so he did something weird to his leg and he couldn't walk. So I took him to the doctor and they were like he couldn't move his leg and they're like, we think he broke his femur. And I started laughing. I was like, his femur? And they were like, yeah, his femur. And I was like, she's like, do you find that funny? And I'm like, that's the strongest bone in your body. And she goes, yeah, we know. That's why we're concerned. And I'm like, do you think I fucking broke his femur? I'm like, he was running on a spring floor in a mom and tot class and he just fucking collapsed. So I had to get him x-rayed and the x-ray showed a split in his femur. And so they were like, yeah, we're very concerned on how his femur got broken. Okay. So then they send me to a pediatric radiologist and the radiologist is like, it's his fucking growth plate. Like, he's fine. So they had him in a cast for 8 days because they didn't want it to, like, heal weird. And it was a split in the growth plate. And I'm like, these motherfuckers were accusing me of breaking my son's femur. I'll break your fucking femur. Oh, I was so mad. Anyways, you guys are the best. I have to go relieve my babysitter. Next week, I will be here Monday, Wednesday, Friday at 11, and Tuesday, Thursday at 8, which is early. But my babysitter said she could come back for a couple more days. And then guess what? In July, we're sending both of my babies to camp. And so I will be able to stream 5 days a week at 11 o'clock. And then in August, I might have to take a couple weeks off because I'm going to give them August off to just let them swim in summer and do whatever it is they want. But we'll cross that bridge when we get there, unless it's Laura Owens and I have to make my mother-in-law move in so that I thought it was going to be me and Bruce, but way better. Do you want me to show that picture? Because it's so fucking cute. I'd love to squeeze it. I want to be in there and be like, group hug. Anyways, all right. I have to go. You almost became a case of... Right. Yeah. Anyways, you guys are the best. I love you guys. Okay, bye. Oh, if you haven't subscribed already, please consider doing so. Like, bang your face against the keyboard. I love you. Bye-bye.